Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. What's up, guys? How's it going tonight? How are you? How's it up? How's it up? It's weirder than how's it hanging, I think. It's how's it up? How's it up with you in your ass or whatever? Okay. New overlay. Oh, I do have a new overlay. What the hell is that? Good job, Brian, the editor. He got that one. He got this one. I like the triangles. That's nice. There we go. Cool. Yeah, you guys noticed before I did. I didn't even know that existed. So good job for him. Oh my goodness. Okay. First, hello. How are you? I hope you're doing well. As always, I hope that you guys are doing well. Past couple days have been kind of weird, kind of crazy, right? We've had so much fucking drama. All this drama. Just a bunch of bullshit drama all over the place. And then Montegraph comes out of nowhere to spooge all over the earth. But that's sometimes how it goes. I look tired AF. I am. I had a trying day, but that's okay. Trying days are just trying days. What we've got today, though, what we've got is 50 minutes of Darrell Brooks going full sovereign citizen in court. We've been waiting for this to happen. I have not gotten to watch it yet, but I'm really, really excited to do so. Sad that I missed it. And so we'll get that started in just a minute. I guess I should start pulling that up here. But the big news is, of course, my Twitch is back. My Twitch channel is back alive. So that's nice. I don't actually know if it came back on its own or if, whoops. I don't know if it came back on its own or if like I beat the strike. I have no idea. I mean, it's been 7 days, so I just assume it came back on its own. But since they never replied to my appeal, I just figure maybe I did win. Like maybe I beat it. I don't know. It's impossible to tell. There's just no communication. So for now, I'm going with I won, and the haters can all drink their haterade and sit around lamenting the fact that they could not actually kiss me. Well, that too, but kick me off the internet, because that's really what they're trying to do, right? They're trying to. They just want everybody that they don't like kicked off. And I happen to be in the crosshairs. And once we got it sorted out, things are going to be pretty stable. I do want to say, I don't think there's going to be a Twitch show tonight, though, as much as I really want to do a Twitch show. Because I do. There horror movies to watch. It's October. And they took that away from me for a week. But I have to be up pretty early tomorrow. So we're going to do kind of the short-ish stream tonight. We'll go until about 2 like normal. Well, like used to be normal. We're not going to have a 5 to 10 hour epic though. And so we'll do that tonight. And then tomorrow night, well, we'll be Flashcast. Maybe there'll be some time for some movies tomorrow or perhaps Sunday. We'll see. But some Twitch is coming, and that's it. What else is there? Is there anything else? Well, of course there is. Of course there is one other thing that needs to be mentioned, and will be mentioned a couple times during the stream, because I'm in full grift mode on this. RekietaLaw.locals.com. This is where you need to be. This is where the magic is happening. We are building a little evil, horrific, probably racist community there, and and it's fantastic. But the most fantastic part about it is, of course, the fact that that it's free. And I don't mean free like you have to pay for it. I mean, that's to really enjoy it, you got to pay for it. But I mean, it's freedom. It's freedom. There's you can say so much on there, and there just isn't anything happening. It's beautiful. What is this shit? Where's the post? Oh. Anyway. So yeah, it's I'm trying to look at something here. What the fuck am I trying to look at? Oh, this is what I'm trying to look at. Sorry, my brain got distracted. We are now we now have how many total? Where's the fucking members? There are no members. Okay, that's good. Can we see the member list? I guess I could go to the stats. Go to stats. We're up to, where is the fucking number? Okay, the stats are down right now. Stats are down. I can't even tell you how many members there are. We're approaching 4,200 supporters in the community. I think we might have broken 40,000 followers over there. That's what I was trying to find. I'm trying to find the total amount, but I do have a plan for when we get to 5,000 supporters on locals, and I have an idea. I don't know how it's going to work, but I have an idea that I'm looking into. And if that idea doesn't work, I'm going to have another idea. But yeah, the main thing right now, the most important thing to know right now is we have an exclusive locals chat with every live stream, with every appearance, whether it's on my show or any other show. The live chat is up. You can interact with the community at all times. And I actually leave the chat. We leave the existing live chat up throughout the night, so there's always a group of people being degenerate, but not quite as horrifying as it is in Discord. Which is weird, because on locals you can say spicier things, but on Discord it's just wow, we got 45,532 followers right now, actually. So there we go. Big update. Last I checked on that number, it said like 39,000. So that's crazy. But yeah, pop on into locals, try it out. Like heroin or whatever. See if you do it once, and then see if you can ever try and get away from it. It's almost impossible. Oh, here we go. Yeah. Someone just generated a new logo for me to help me avoid all bans on every platform. There we go. This is how we're going to do it, ladies and gentlemen. This is how we're going to beat the globalists. This is how we're going to win. They're scared of us. These global homo pedophiles. We need the protection of Israel. So that's what we're looking for. But anyway, we are. I am trying to grift my way to 5,000 active supporters, and then after that, I mean, it's not going to stop. I'm going to try and then grift my way to 10,000 and more. So much so that what we're going to try and eventually do is get to a point where there doesn't ever have to be a super chat or rumble rant or anything else ever again. That's what we're going to do. And it's going to be great. And it's going to be fun. And it's going to be gay. We're going to be frolicking in fields like a bunch of happy retards. And then that'll be fantastic. Then we'll all be sovereign citizens, and we could all get arrested. We could all go to the judge and be like, "Who is the state of Wisconsin? Have you ever met the plaintiff? I've never met the plaintiff." That's there. Okay. Okay. K to the Swiss says, "Oh Christ!" Then you've got this big nut nose sack. Yes. Fac Uniga. Monty has a call-in stream on 10/15, which is tomorrow. It would be a shame if thousands of people showed up. It would also be a shame if there were several callers who pretended to be from unnamed federal offices. Look, I do not endorse anything regarding Montegraph, including his life continuing. What a fucking weirdo that guy is. And you know what? If Montegraph disappeared tomorrow, I really probably wouldn't notice, because I only notice when he shows up. It's kind of lame that way. Frenchie JJ will soon be starting a small stream talking with very basic local small town politicians about small town life. Would appreciate a good luck. Cheers. You're an inspiration in weird ways, my guy. Well, okay. I might have to go get, I don't want to drink all this. Give me a second. I need another bottle of liquor. I'll be right back. This is top shelf streaming right here. Okay. Oh, man. Talk about being a professional. That's what you do. Okay, we've got this Wiggle Rye. Sherry cask finished Wiggle Rye. I've had Wiggle before, but not this one. This looks good. Hassan reaction video stream. What the fuck? What did Hassan do now? Hassan's an idiot, but what is it? What's he doing? I mean, what's he up to now? What's the new thing? Okay. My fucking headphones back on for Darrell Brooks. Oh, is he? Did he react finally to the full meltdown? Well, somebody give me a link. We can laugh at that. We got Darrell Brooks, and then we'll have some time, probably, maybe. Here we go. Let's see. Oh, yeah. So this is to Frenchie JJ. A cheers and a good luck to you on your streaming endeavors. I hope you find success and don't want to off yourself after talking to a bunch of local politicians. Good luck, brother, sister, whichever one you are. Cheers. That's a bold flavored whiskey. Okay. All right. Damn. Not sure about that one. Okay. I'm not sure on that one. That one's got a weird flavor to it, but we'll try it again in a minute and see. Thought this was just free flow Friday, no topics, just talk. I mean, kinda, except we really did that on Wednesday. We really did that on Wednesday. So we're gonna do this this Darrell Brooks video, and then we'll see what happens. The reason I didn't invite a bunch of people over today for the kind of free flowing talk that we do on Friday is twofold. One, Wednesday happened, and two, those shows tend to go 5-6 hours, and I literally can't tonight. I can't do it. Here we go. Let's get to Darrell Brooks here. All right. Okay, so this is from yesterday at trial, and this is, I think they came back from a break, and they're going to deal with some preliminary matters.
Took our break. All right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
Don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client.
You don't have a
noted
client.
For the record.
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The record is clear and accurate, you fucking idiot.
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. We still haven't.
God, you fucking retard. You have subject matter jurisdiction over crimes.
That
All rise.
This court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the military
All right, can
power?
you please take the jury out? Thank you.
She has tolerated this shit for a really
You hold
really
the
long
full
time.
Mr. Brooks, just wait
jurisdiction.
till the jury's out, please. I ask that you show that respect.
I will.
Thank you.
He finally found the end of the judge's rope, I think. Finally found it. By the way, if you do enjoy these streams, please click that plus on the Rumble site or the little thumbs up on the mobile app. It really does help drive this show to the front page. Put it in the top 50 every day. That helps more people find the channel, find the show.
You all can be seated. Mr. Brooks, just make your statements. What do you want to
What do you want?
advise the
Brooks?
court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
It's military power. I'm going to
sorry?
shoot you.
I don't understand what you're asking me, sir.
I'm asking,
On what legal basis are you?
This is what she's needed to do for a while, but it's going to take a shitload of time. That's why she hasn't. She's going to make him walk through retard logic all the way to where his point is, but he doesn't have a point. He's just reading statements from some pamphlet that every sovereign citizen gets when they're spit out of some rotten vagina years and years ago. These fucking weirdos come out and they try this shit all the time. It never works. It never works. It doesn't ever work. If you come up to me and be like, oh, you just don't know about that one time that the sovereign citizen, I'd say that one time that it worked, it still didn't work. That guy was just a retard. It never works. It never does. It isn't real. It's just fucking not real.
Making that request.
I'm asking for the record, is this a common law court or an admiralty court?
It's not an admiralty court.
What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor,
there isn't a certified copy of a court docket sheet.
I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office.
There isn't,
which you are required to show if I ask for it.
No,
I've brought up my Sixth Amendment constitutional right that has been pretty much discarded. And that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim.
That's so untrue.
I've requested
First of all, corporate personhood has existed ever since corporations have existed. It's a legal fiction that creates a personhood around an entity to get around this. Like, no matter how much people hate corporate personhood, there's a fucking reason that it exists. It's so that they can sue you and you can sue them. But the state of Wisconsin isn't a corporate person. It's a sovereign entity, and that doesn't... There does not have to be a person to bring a claim. There never has. The judicial power does not only contemplate person-to-person claims or causes of action. The judicial power has forever, at common law, contemplated the crown, the throne, the state, whatever you want, to be an entity sufficient to bring charges and challenges against someone. The sovereign citizen nonsense has never functioned, ever. It is not based in law. Like, maybe they think that's how it should be, and that's a wonderful thing to argue in some shitty book that you can find in a $3 bargain bin at Walmart, but it's not anywhere in the history of the common law. The common law is built upon primarily English law going back for centuries. And in all of those centuries, guess who always had the authority to bring suit or charges against any person? The fucking king, the crown, the executive. And so when you get to the state of Wisconsin, its executive branch has the ability to bring charges against you because it mirrors the common law of the crown itself. You may not like that, but we have a king called a president that we reelect every 4 years, and states have a governor that is also a king that they call it, that is reelected every 4 years. And that entity, that executive entity, is empowered with the executive powers of a sovereign. And those executive powers have always included bringing suit in courts. They didn't have to. They didn't have to have courts at all. They could have just killed you. And for a long time, they did. But then they created courts. And they're like, well, yeah, but now the king and the crown have to be able to bring charges against criminals to prosecute them. This is not a thing. Is like sovereign citizen is based on the fallacy of antiquity. Like, oh, this is the old law, which is better and more appropriate. But it's actually not old. It's actually not old at all.
For the complaint to be provided. The complaint from November 23 of 2021, the amended complaint from November
Those are
29th
in
of
your discovery
2021.
documents.
The second amended complaint from January 12th of this year, 2022. I have yet to see those. There was no record
Only
of a
because you don't
bond
want to see them.
in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum, I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor.
And you think that's going to get you to win?
Has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand.
You have been served the
why
complaint
these proceedings
and the amended
are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery.
They're all in your. They're all in that box next to you.
Provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter.
Okay, good.
And I believe that it should be verified and it should be proven.
This is the dumb fucking game. Well, if you don't provide me a certified copy, then the copy that you provided me, which is a copy of the complaint filed against me, which is also read into the record in court, by the way, unless you waive reading your complaint into the record. People may not know this, but at one of your first appearances, you will have the opportunity to have your record, the record of your charges, the complaint read word by word into the record. Everybody waives this because it takes forever to do so. But if you want it, you have a right to have it read into the record. Otherwise, if you waive said right to have it read into the record, they just adopt the draft the draft criminal complaint that exists. And when it's amended, you get the same right every time. It was probably waived by his public defenders before he fired them. He probably agreed to have it waived because everybody agrees to have it waived. Everybody agrees to have it waived. No one wants to sit there and have someone read 70 fucking charges out. It gets really boring. But even so, like a certified copy is irrelevant to this. The question is, are the copies, is the uncertified copy that you have substantially different than the certified copy would have been? No, it's the same fucking thing. It's just missing a stamp. But that stamp doesn't mean anything. It doesn't do anything. It's just a clerk saying under oath that this is a true and accurate copy of the claim. But that's irrelevant to whether or not the claim exists.
Proven for the record. And if not...
Oh, but he's trying to play this fucking semantic game where if it's not some certified copy or verified copy... And by the way, if they gave this fucking idiot a certified copy, he'd say, well, who's it verified by? This is a clerk. A clerk doesn't have authority to do this. What about you, judge? I want you to certify it, which the judge doesn't do. This is how it goes. It's all bullshit.
I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying.
Those are rules of civil procedure, by the way. Failure to state a claim upon which relief can be granted is for civil matters. It's a 12B6 motion in federal court. Each state has its own version of 12B6. I just don't know the numbering for each one because it doesn't matter. This isn't a civil procedure. This is a criminal procedure. There are different rules of criminal procedure. There is no plaintiff in criminal law. The state is the complainant. The state is the accuser. But also all witnesses who have made any statement to you, that's your accuser as well, and you have a right to confront them under the Sixth Amendment. That's true. But he's getting that right. He has that right for cross-examination. And anybody who provided any statement to any law enforcement agent at all, he could subpoena them. He absolutely can and confront them if he wants. Because there are plenty of people who saw him run over little kids and grandmas and stuff like that who are not appearing in court. He could call any of them.
It has merit and it has validity. As we see here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days.
Then you get a chance to
There's
say
so
that
many
on
things
closing
left
argument.
to still be proven.
Yeah,
The
that's what trial's
prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet.
They all have attorney numbers on every filing that show their
There's
bar
so many
registration.
things. And Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power?
Neither of
hasn't
those are
been
true.
proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over.
What?
No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified.
I asked for everything.
And to be filed into the record.
I asked for a sledgehammer to hit you with.
It's to the point where Your Honor, you should recuse yourself from the presiding.
Just recuse
at this
yourself.
point.
You've been
If
very
you're not
unfair
going
to him.
Abide by the oath that you swore, which was in your oath, correct?
Man, I'm not sure about this.
You swore
This whiskey
to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or
tastes like another bad bottle. I wonder if something's
causing
going
a problem
on.
when I'm merely
weird.
seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided.
Is that dog the bounty hunter?
Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided?
Hey, you fucking idiot. It's almost like you could just make a legal argument if one existed. First of all, one doesn't. But second, sitting here asking the court, like if you're sitting in court and you're like, Your Honor, is there any legal basis by which I might be not guilty? She can't say yes or no or provide you a legal basis. You have to go, Your Honor, here is the legal basis by which I am not guilty, and make the argument. This motherfucker's out here just asking questions. The questions are stupid. And even if he asserted them, the answer would just be no. But my God.
Why the docket sheet is incorrect. Why there's so much on the docket sheet that should be on record that's not even in there. That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done.
Please go on and on and on. None of us want to jump off a bridge already.
Face my accuser. Where's the injured party? Who's making the claim?
You killed 6
I asked
people.
Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record, a non-responsive answer. A non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor,
A
that
tactic.
you don't have to answer these questions that you should be answering.
It's tacit, you fucking dummy. But here's the idiocy of this theory, of course. If you just kill someone, if you just kill them, well, then there's no one who's no injured party to complain against you. So you're fine then. Unstoppable. Like, what the fuck? What do you think?
I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question.
It's not
The
a valid
plaintiff
question.
should be present in this matter.
The state of Wisconsin
Where
is
is the plaintiff?
represented.
Who's bringing the claim?
The district attorney.
Because we know an entity can't bring a claim.
That's not
It
what
has
we
to
know.
be a living, breathing human being.
It's not true at all.
No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person.
Not one.
I have the right to demand that the court place in the evidence any unrevealed contract.
What?
Has that been provided to me? Has that been placed in the evidence? I would like to see it.
No, if they would be revealed contracts then.
I have the right to inform the jury about the truth and their duty.
The truth.
And their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know.
Those arguments during closing
Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly,
so the unrevealed contract thing is actually like part of criminal law, except he just doesn't fucking understand it. If there is a contract of some sort of cooperation between a prosecutor and a witness, like say, if you testify on this, we will drop this other charge. We will arrange more favorable bail conditions. We will do that. You have a right to question about those things, to have them provided for you, like a plea agreement of some sort or whatever in discovery. You can request those things. You can ask questions about them. You can reveal them. There aren't any in this case because you're the only fucking criminal. The people you ran over don't have a contract with the state to testify against you. They just hate you because you killed their kid.
it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know.
Yeah, you do that during your opening and closing statements.
It would be a travesty for them to make a decision without being fully informed.
You have the opportunity to do that.
And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down.
It's because your objections are invalid.
Numerous times.
They don't have a legal basis.
I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution.
Bullshit.
We haven't even talked about that.
Bullshit.
Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea.
I find that to be absolute bullshit, by the way.
That's another issue.
This is the other thing. This guy is a documented habit.
I have the right to challenge the
documents being
jurisdiction
placed
of
in
this
front of him.
court, which I've done numerous times.
Documents being placed in front of him and him going,
I have the right
"No,
to
it doesn't
demand that
exist."
the code be construed in harmony with the common law. I just raised that.
He's reading.
I'm constantly
a sovereign
referred to as
citizen
pro
Bill of
se
Rights.
when I've raised the issue that I'm pro per. I have the
Pro per
right to
and pro
conduct my
se
defense pro
mean
per free from
zero
professional
difference.
restrictions
There's zero difference.
imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year.
Nope, you've had a whole year to prepare for it
We
too,
see
buddy.
these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September.
Yep.
Which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the
you're forgetting the year of
digital
time that
discovery and
public
things of that
defender
nature? How can I
had
go
to do
through
this.
all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well,
that's your fucking choice. That was your choice. The state, the other right that you have is to be provided in a competent counsel to stand and defend you. And you fired those guys because you wanted to pull this bullshit. You're trying to pull a bunch of gay bullshit because you're a gay fucking murderer. Go kill yourself. God, you piece of garbage. Fucking hate this guy. Can we just put him at the bottom of a hill and like let an SUV roll down it? Can we just do that? Menacing Scarab says, can you explain what he means when he says the line, I accept for value in return for value, because it makes so little sense that I can't even begin to guess at it? Okay, so what he's referring to is this principle of contract law. Contract law says that there needs to be consideration in any contract. All right. So there has to be an exchange of value from each party. That's the consideration to have a valid contract. If you don't have an exchange of value, it doesn't have to be equal value. It can be vastly unequal value. But if you don't have an exchange of value, you don't have a valid contract. So this retard is sitting here saying provisions of contract law as if they matter in a courthouse at all. Like someone handing you a document does not mean you have some contractual thing with them. But the sovereign citizen argument is that effectively they are divorced from the state. They're divorced from the state's authority and power. And so since they're divorced from the state's authority and power, since that exists and is true, then they have to operate outside of the typical structures of the state entity, which means they operate entirely by contract and consent. That's their thought. It doesn't work that way. It's never worked that way in any jurisdiction. There we go. Ryan, the editor, has created the cuck logo along with the banner. So very, very nice, Ryan. Good job. Good job, friend. This idea that a state entity does not have jurisdiction over a criminal act within its own borders is stupid. It has never worked because, of course, the state has jurisdiction over a criminal act that violates state law within its borders. The only time the jurisdiction works is when something should be state or federal jurisdiction and is brought in the improper court. But running over people in Wisconsin shockingly falls to Wisconsin state criminal courts.
Well aware that I was not prepared. I raised the issue that it should be an adjournment at least at the minimum, it should be an adjournment because of that fact.
For how
at
long?
At least to let me go through all the discovery.
How long would that have taken you?
That was denied.
Yep. Good.
No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days.
You had a year.
That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make?
You could have subpoenaed anyone you thought was the injured party that you want to question. You chose not to. You chose to send out 13 retarded subpoenas because you're a fucking moron.
A claim against me, Your Honor?
Yes, I have a claim against you right now.
Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter.
Just deny it.
So who makes the claim? Who?
I don't know. Who, Darrell? Who makes the claim? If a dead
I have the
child
right to put the judge on notice of my
If
intent.
the little dead fucking kid was resurrected right now and came in and made the claim, he'd be like, well, he's not injured. He's right there. I can seize that he'd not be injured, but I want to ask him some questions.
To appeal in any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but
Yes.
My right is that I can raise that issue during the case,
Not in
which
this
I've
court.
attempted to do. That's been shut down.
You got to appeal it to the appeals court. Your lawyer would know that.
I have the right to specifically reserve all of my rights, which I do at the beginning.
I resurf them.
I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally
You're doing it out of order.
The court to be disrespectful, which I've stated that
There are time, place, and manner restrictions on speech. In a grand scheme of things, I'm not a big fan of time, place, and manner restrictions. However, in court, they set up for orderly discussion and processing of facts, a structure for when you can talk. That's about it. You can say whatever you want, technically. He can get up and say just a bunch of racial slurs. He'd be fine. I mean, the judge would ask him to stop. May hold him in contempt, and he might win that, though. But it doesn't matter because your First Amendment rights exist, but within the structure of the court system for judicial economy. Because if you could just say whatever you wanted all the time in court, court would never end. We'd still be on the first case. Because you just filibuster constantly, which is what he's trying to do.
that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone.
What
But
about the people you
because
ran
I
over?
don't understand,
Was that disrespectful?
I raise these issues because they have validity.
They don't.
I have the right to object to any statement made by the judge or the prosecution. I've done that and
You
been
already said
repeatedly
this.
shut down
You already said this, you fucking idiot.
without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit,
Oh, without merit.
which is also my right.
Your right to be denied without merit?
I
That's
have the
true.
right to recuse the judge
No, you don't.
at any time,
Nope.
which is also a right.
I mean, listen to the lunacy of the retard pamphlet he is pulling from. I had the right to recuse a judge at any time. Oh, okay. Yeah, there you go. That's a system that'll function. Any stupid moron just murder someone, and then every time the judge says anything, they get, well, judge, you need to be recused. Not for just at any time. That's my right. Just recuse every judge, and then when they hire a new one, recuse that one too. I wonder what website. God, I wish we knew what website he pulled this off of. Wait, Overlord 26 says, Rekieta, I bought my first whiskey still from my distillery. My wife is now in her third trimester for our first child, a baby boy, asking for a toast to successful business and a healthy baby. Well, this is going to be awful. I got the last sip of this really shit whiskey, which may have gone bad. I don't know. I've not had whiskeys go bad, but this just can't be this terrible. Cheers to you and your wife on the upcoming first baby. A baby, a boy, a son, someone to raise in the image of yourself, but hopefully a little bit better. And also congrats on getting a new whiskey still. May your distillery be fruitful and profitable. May it bring you joy to labor over something and then distribute it to people who will enjoy it. Cheers and good tidings to all of the good things to come, brother. You got a lot to look forward to. Ugh. That's fucking terrible. Well, I'm not drinking any more of that shit. Ah. Ah. Ah.
I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been.
I want this case adjourned, but I want my speedy trial. But I want this case adjourned and delayed longer. But where's my speedy trial? You can't have both, you fucking idiot. You had to demand your speedy trial when they asked you before. You waived your right to it. They would have had to try you within 60 days or something like that. You still would have lost. You would have lost way worse.
Taking place for roughly a year. I've never consented to waiving anything related to a speedy trial.
Bet it's on the record.
And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial.
You wanted adjourned.
That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from
It's
the way the
actually not
motion was
obvious.
presented, the coverage alone, the political
coverage.
campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter.
Wait, there
That
were
is
no
a
injured
clear
parties.
conflict.
There are no injured parties. What are you talking about, Darrell? No injured parties. But again, the lunacy of, yeah, a state can't prosecute you if you just kill enough people that everybody knows someone you killed is impossible. The question is whether those connections generate an actual bias. You had the opportunity to voir dire witnesses, find those biases and conflicts, and strike those witnesses for cause. You didn't do it, though, because instead you sat there spouting off from a bunch of bullshit. Let's see. Oh, God. Here we go.
Big conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that
doesn't mean anything
when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs and I know what professional relationships is and personal relationships. I've never had.
I'm pressing a huge fucking X to doubt on him working numerous jobs and understanding the difference between personal and professional relationships. I don't buy it for a fucking second. Hockey VG, for an SUV, this vehicle is speaking relatively well. I'd expect this more from a sedan. Should really bring up that the DMV is full jurisdiction and not this court. Oh, Jesus. QTWIQ says, Nick, this old broad enjoys your show. Thank you. Grounds. Hey, thank you. Thank you. This is, so again, you can find evidence of bias sufficient to bring a recusal. You can find some sort of conflict or whatever. You need to make the motion for recusal. When it's denied, you need to immediately request an interlocutory appeal or file for writ of mandamus from a higher court based on the grounds for recusal that you cite. A lawyer would know this. A lawyer would know how to do this, and a lawyer would have done this if it were proper in this case. But this judge has never once shown a bias against this guy. In fact, this judge has been infuriatingly and insufferingly tolerant of this fucking idiot. No one could argue that she has treated him unfairly in any way. You don't get to do this, by the way. You don't get to sit and just spout off for 45, 50 minutes in court. Like this does not happen. If he were an attorney, she would have told him to sit his ass down or she would have held him in contempt. That would have been the two options.
The cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. That would constitute a personal relationship of some kind.
Nope.
Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record.
Oh my God.
Again, I go back to the Sixth Amendment again. in terms of when I asked for the motion for the evidence motion that I raised. That was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract.
Secret witness has been revealed.
That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all
Literally
know
zero. The guy who completely waived his Sixth Amendment right, the guy who sat there and argued for a waiver of his Sixth Amendment right. It's like there's been repeated violations of my Sixth Amendment right. Chigon, my sister struggled with pregnancy for years, but just found out she's pregnant from IVF. Please give us good wishes and hope. At least we get some good news sometimes, but it's hard not to be worried. Chigon, cheers to her. Best wishes for her health, for the healthy development of the baby, for the wisdom of doctors, and hopefully they'll be having their hands on this one pretty directly, and we'll guide her through. Good luck.
The United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void.
Yeah, I guess
We know that.
that you can't murder people with a car one is probably null and void, right?
There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery?
What?
Why was the motion to prove jurisdiction not verified? Why was the
Not
motion
verified?
to dismiss the case for all the reasons I said not being granted?
Because you lost the motion.
Which brings me to the motion to subpoena witnesses.
Why didn't you grant
I
my
did
motion?
everything
Why
that was
wasn't my
asked
motion
of me
granted?
by the court pertaining those subpoenas.
Yeah.
It was understood by the court that this is my first time ever having to do this.
Yes.
I didn't understand how to properly.
By the way, pro se or pro per litigants always are held to the exact same set of rules as attorneys. They're expected to follow the same rules. You do not get special deferential treatment. Now, a lot of courts will defer. She's helped him numerous times on kind of the mechanics of the courtroom process, but you are not exempt from any deadline. You do not get special treatment or consideration on any rule, motion, objection, anything else. You have to provide the legal basis for your objections, for your motions, and they will be ruled upon in the same manner as if you were an attorney making them. You don't get special treatment for choosing to be unprepared or having less knowledge than needed to levy your defense. You don't get that. Like there is no, well, I'm stupid, so I need help from the court thing. That's not how it goes. That would be prejudicial. Because what if the court didn't help you enough? What if the court helped one person more than another? What if the court did X, Y, Z? No, you are held to the rules, the same rules everyone is held to, and that's how it goes.
Properly fill out the subpoenas at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right.
Yeah, that's all the assistance they can give you.
That doesn't amount to any assistance. I was still left to fill it out on my own. And then when I did that, correction still had to be made, which would verify what I was saying. I don't know how to do this.
We know. You had counsel. You fired
but I
them.
still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser?
Can someone Photoshop a sub penis? Like a giant submarine cock coming out of Darrell Brooks's pants?
How could the subpoena not be filed?
Maybe the judge is a Fuda with a sub penis.
And how could the plaintiff not be called to the witness stand?
Oh, please call the state of Wisconsin to the witness stand. That'd be fucking great.
That begs the question of, does the plaintiff even exist?
No, he doesn't
Which it was
exist.
stated for the record that not only by a witness, a detective, Detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim?
There we go. Here. Perfect. We've got the state of Wisconsin. We've got the state of Wisconsin.
Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom?
Yes.
No, they will not, because they don't exist. Therefore, the claim doesn't exist.
The state of Wisconsin doesn't exist. That's interesting. It's now joined Australia.
For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor.
Their license
Why was I
number
not
is
provided with a certified copy of your oath of office?
is on every single document that they filed.
Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that.
Wait, what?
So why wasn't that proof verified?
What name registered by the Secretary
You
of
gave
State?
me a copy of your oath of office, but it's not certified. So how can I verify that that is the true?
If it was certified, how would you verify it?
You signed. How can I verify that it's valid? That's the reason why I asked for it to be certified.
You wouldn't accept
which
a
you stated for the
certified
record
copy
you will not do
anyway.
that. You never stated any legal reason why. I have the right to ask for that
No, you don't.
legally.
You don't. I mean, you don't have the right to be given it.
I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter.
State of Wisconsin watched you run over its children.
I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people.
Yeah, you can challenge them. This guy thinks that you have the right to doing something means you have the right to win.
From my knowledge,
oh God, don't ever say that again.
The design of the statutes of the law was written
statutes
for the common people to understand.
Yes.
So that would mean the final determination or interpretation of what the law says comes down to the people.
What?
You know this, Your Honor.
Well,
Are you not a public servant?
she's just sitting here.
You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever
What
seen
is your
that
name then?
or individual.
What's your name then?
Every single filing or paperwork was all in capital letters. Ever since
Yes, for clarity, not
September
for accuracy.
29th, roughly around there, now everything starts to go to lowercase letters. Why is that?
It literally.
What prompted the sudden change?
What's your name then? What's your name?
I
What's your
still
fucking
have
name?
filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client.
That doesn't work. You don't have a client. You waived your right to an attorney. You waived the right to an attorney. You fired the attorneys representing you. You don't have a client. You're not a third-party intervener. You're a named party to the trial. Like, you're done, buddy. Like, you can't just say that. It's not, it doesn't make it so because you say it. Sovereign citizens need the fucking gas. I don't know what needs to happen. Like, it's insane how fucking retarded these arguments are. That's not my name because it's in all capitals. Well, what's your name? I don't consent to a name. I have no name. Suckly Force says, recently got married. Can you toast us? And do you have any advice for a smooth marriage? Smooth marriage. That's funny. Those aren't real, bro. Also, do you have any advice for dealing with burnout working at a law firm? No, I worked for my own law firm. I could never have worked for some other law firm. It would have been terrible. I have problems with authority. That should be really obvious. But no, so I really, I don't find, I'll give you the advice I would have for any generic burnout that you have. You need to find your thing, find your zen, find your happy, and make time for it. Sometimes you've got a wife, right? Like, so that's going to be soaking up a lot of your time, but you need to probably sacrifice some sleep or something else to find your happy, whatever that may be. Maybe that's a hobby. Maybe you rebuild cars, maybe you play video games. I don't know what it is. Maybe you read books like some sort of fucking nerd or something, but find time for your happy. It's going to be really hard because you're working with a firm, got burnout. I tell you're working really hard. But the other thing, no, there is no advice for a smooth marriage, man. There is no such thing as a smooth marriage. They don't exist. But here's what I will tell you is that the rocky parts of marriage are what make your marriage interesting and show you that it has value and is worth all of the shit you're going through. If it was smooth, it'd be because you were both indifferent. If you're indifferent, there would be no purpose to being together at all. You can be indifferent with any number of people. Marriage is different. Marriage is a bond of commitment to each other. You chose that. And that means good and bad, you're going to take it all. But that's what makes it important. And so I can't give you advice for a smooth marriage, but I can give you advice for a committed one. You tell yourself every day when you wake up, I'm going to make this happen. I'm going to make this work because I really, really like that other person. If she does the same, you guys are on the right track. Cheers, brother. White guy says, Darrell has finally won me over. Not all women have a sub penis, and not all men do. The amateur iconoclast says, Brooks is right. Wisconsin doesn't exist. It's actually an exclave of Florida. That explains all the batshit crazy crimes occurring there lately. Well, that'd be even better, because then we could just move it to the jurisdiction of Florida and he could get the death penalty.
Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case?
Because
did you take it upon yourself to add
that's a federal case.
This 4th option to
it's
justify
a federal case, and those are non-exhaustive
denying
lists.
me my constitutional right by being present?
Oh, we finally got a sub penis. And I think Brooks is jerking off his sub penis, which is disturbing, but we've got to, very graphic pornography on screen right now. Darrell Brooks jerking off his sub penis. Very, very, finally it's understood. I now know what he's talking about. Oh my goodness. It goes all the way. The shaft goes all the way down. This is a disgusting picture. Oh, I'll await my imminent ban from Rumble for the pornography. Let's see. What the hell do we have here? Raceland 9000 says, it sounds like all sovereign citizens have renounced the protection of the law and state. Anyone can invade their sovereignty and smack the stupid out of them. They'd be the first ones to call the police and run to court. They literally, oh, Jesus.
You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case.
None of these people at all, by the way, none of them would adhere to the true principles of being sovereign from any state, where any person could just come up and just kill the shit out of you because and face 0 consequences because you're outside of the jurisdiction, or just beat the piss out of you, take your stuff. What's it going to be? Oh, since you're not in the state, then the state doesn't have jurisdiction over you. Then you can't bring a claim against them within the state that you don't recognize. So you would have to, I guess, wage war against the state entity, for the harm done to you by an actor of its agency or some weird shit. Like, what would happen? Just go steal stuff from every sovereign citizen. It can't be illegal, apparently.
Where does it say you can create a 4th option?
Wonder if he's ever taken a state benefit.
Not upholding my
Easiest bingo
constitutional
game in
rights.
history.
I'm sure you know about Title 18.
You don't have constitutional
USCS
rights. You don't recognize the Constitution.
Which states that it's treason not to uphold your oath of office. Treason.
Oh, God, if only that were true, we could just hang all of the Congress people. It's not true, brother.
You repeatedly make judicial determinations that clearly prejudice in my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down.
My head's gonna hurt. Oh shit, I missed this one on Odyssey earlier. Sausage Fingers, my man, I'm sorry for not seeing this one earlier. He says, before this trial, I hated Brooks in abstract for the heinous crime he committed. After watching a bit, I hate Darrell Brooks on a deep personal level. Not only is he a monster, he's one of the most aggravating people I've ever seen. How this man has gone through life without being beaten to death is beyond me. It is beyond me. I can only
Leads
conclude
to
he must not be like this
today.
normally.
The constant push not to have an informed jury.
Wait, not to have an informed jury?
Not giving legal valid grounds on objections, not noting objections for the record to make sure that the record is clear.
Oh, okay. I see this one in locals. I want to do this real quick. I'm sorry. Crystal Pontac says, Nick, would you do a toast to my grandfather, Adam? Sitting next to him now and he's slowly fading. I might only have him for a few days or hours. He's my favorite guy, then my dad, then you. Keep it cool and stay blessed. Crystal, to your, to your grandfather. To your grandfather. A man who's clearly inspiring to you and has given you a profound outlook on life built on years and years of experiencing it firsthand. May the wisdom, the joy, the laughter, the tears, and the lessons all amount to you becoming a better person, following in the legacy that he has set. And may that legacy pass on to the next generation, to those you meet, and to those you influence. Cheers to you. Cheers to him. Enjoy your remaining time. All right, now back to this horrible idiot.
I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing the claim.
You got to review the jury instructions and offer input on them.
But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in the timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait to the next day. That's a clear bias and a clear prejudice to my defense.
Oh. Why does the filing and timestamp have anything to do
privileged
with,
to the same
with prejudicing your defense?
Filing system. Which brings me to the reason why I brought up the issue of assistance of counsel.
Oh, come on.
Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel.
You
having
waived your Sixth Amendment right. You argued to waive it.
Counsel is two totally different things.
Not for you, brother.
You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that.
Did you sign it?
Any contract can be altered if I don't agree to certain terms.
What term did you not agree
crossed
to?
Out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to
You
speak
can't
for me,
have
but
standby
someone
counsel.
to help
You
me do things in a timely
do
fashion.
not have a right to
Get
that
things
from the
filed in
state.
a timely fashion.
You don't have
Get
that right.
motions together in a timely fashion.
Nope.
Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it.
Here's the problem with his advisory council. I think that he would actually have the ability to hire private advisory counsel. I think he has the ability to do that. I'm not sure there's a ruling made on that. He cannot demand the state of Wisconsin to provide him standby counsel. He can't do that. And so he's trying to make this distinction here. Well, he has a right to be given it. No, you don't. You waived your right to counsel. You waived it. You fired them. Jaster002, this man is a Oswald Bates come to life from In Living Color. I'm not familiar with that. I don't know, man. Sometimes like you get, I think I'm in a bad mood, but you get these people, right? You get these people who come out here and they try to just, I don't know what he thinks is going to happen. I know that there's somebody out there who has convinced this guy that these stupid arguments are definitely how he's going to beat his rap. Like, I know that he's read some pamphlets. Says not they can't do this to you, brother. You are having your rights violated. Here's what you need to do over and over and over and over again. But it doesn't work that way. It can't work that way. If it worked that way, no one would ever be guilty of anything, because all you'd have to do is just be fucking dumb. Like, you'd just be dumb and you'd win every case. But that's not how an ordered system works. An ordered system does not work based on your refusal to understand or be informed of the rules and law. It may not be fair because the legal system is so fucking convoluted. And if we want to have a discussion about that, I'm fully in line with having a discussion that the legal system is overtly convoluted. It is unintelligible to the average person. It requires way too much training to know what's going on. We should reduce the number of laws. We should make them into more plain language. I am with all of that 100%, but we aren't there right now. And all of the rights that this guy is afforded have been given to him in spades. Dramatic amounts of right respecting going on that doesn't need to happen. The court could be shutting him down right now. Let's see. Nickel Song says, Rekieta's argument that you waive your right to court-appointed lawyer means that you waive your right to advisory counselor. Essentially, any representation makes you slave to the quality of a court-appointed lawyer. Very convenient for a lawyer like Rekieta to say. First of all, that would not be convenient for me to say at all, but you waive your right to be given by the state counsel. That's what you're waiving your right to. You have a right to be provided counsel if you cannot afford it. That's it. That's your right. And then the state can't just reject you bringing counsel to court. You have a right to representation. Once you waive that, though, what are you going to do? What do you want this person to do? What do you want the state to do? The state can't just okay, you fire all of the lawyers, and then the state will then hire the lawyer. I want Johnny Cochran every time. That's who I want. I want the prosecutor to come represent me. Impracticality. Impracticality is rife in sovereign citizen arguments, but practicality is present in one very specific place. The Birch Gold Group. The Birch Gold Group is a practical group of humble gold merchants and silver, I guess, who would like to help you determine if your IRA or 401k could use a little bit of gold and silver in it, a little bit of sparkle in there to help weather the difficult volatility of the market, inflation with spiking and dropping stocks, with a crazy Fed changing interest rates all over the place. Birch Gold Group offers you the opportunity to take those retirement accounts that are meant to just sit there for a while and add a little bit of stability through those physical assets that are resistant to a lot of the volatility and change that exists in the market. These are not the type of guys who are going to be like, yeah, you got to buy gold because gold's going to spike up 8 million %. If gold is going up like that, we've got real fucking problems. That's not what we're talking about here. We're talking about using this as a hedge, as a part of a rounded strategy within your portfolio. These guys help make it happen. And the easiest way to get that help is to click on this green button after you type in birchgold.com/knows. It's also linked in the descriptions on both Odyssey and Rumble. And you click this green button, they'll get you some information about it so you can make the determination of whether it's the right thing for you to do. Maybe it is, maybe it's not. And if it's not, it would be a terrible, terrible thing to do. But if it is the right thing, it might help out your portfolio as we face a ridiculously inept administration who has caused quite a bit of turmoil, we'll say, in the markets. Also, Montegraph approves. Call now, the Birch Gold Group. And if you don't, Monty will come to your house and he will sit down and do a live stream in front of a plain wall that is really, really boring while you're asleep. That's what'll happen if you don't call them right now. They told me this. Birch Gold Group specifically said, if they don't call us, Montegraph's coming. So that's true. That's definitely not a joke. That's a true fact. So check them out, birchgold.com/knows. As always, the main reason that I am supporting Birch Gold is very simply because they said, hey, we'll support you. We want to do an ad on your show. We know who you are. And we would like to work with you. I said, what can't I say? And they said, just be you. We're not going to put any limits on you. We're not going to give you a script to follow or anything else. They support the idea of free speech, and all they want to do is sell you some gold. They want to just see if you're the right person to buy it. That's it. Give them a shot. birchgold.com/knows. Okay. What the hell is going on in this? This locals chat is insane. This show is also brought to you by the locals, rekietalaw.locals.com. If you're not in there yet, you should be. You should be in there. You should be joining, and you could be having fun with the rest of us with all sorts of pretty offensive memes from time to time and a ton of free speech commentary. Locals chat is best chat. Make sure you check it out.
That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that with no objection, that becomes a tacit agreement.
Tacket. It's a tacket agreement.
But yet I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense.
Here we go. The Rumble chat or the locals chat seems to have found his document, the Court Survival Guide, Copyright, Sovereignty, Education, and Defense Ministry. Wait, how are you filing for a copyright? Litigation tool. Here you go. Here's the list of rights. You have the right to this looks like exactly what he's been reading from. So big Big props to them. This is why you have the right to conduct your defense pro per, free from the professional restrictions imposed upon licensed attorneys. This is not actually true at all. You have the right to submit motions, fair trial, change your plea at any time before trial, appeal any judicial decision, speedy and fair trial by an impartial jury. See, he said that you could do it during the pendency of the action, which is not true, actually. You can't always make an interlocutory appeal. There are rules around it. Right to waive court and transcript costs on the basis of pleading in forma pauperis, no money. You have to qualify for in forma pauperis. You don't necessarily get them. But this, of course, is actually usually a civil matter. You have the right to due process of law trial before you are deprived of any liberty, property, or money. Fifth Amendment. Right to face the injured party claiming damages. Article 3 in the Sixth Amendment. Face your accuser and witnesses against you. Yeah. Yes. Yes, you have all of these things. But he doesn't seem to understand what these things actually are. So there is a guide. That was page 6 of 42. Here we go. All right, here we go.
Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day.
Yes.
So I'm roughly locked down 22 hours a day.
You're in jail, homie.
Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial.
What are you talking about?
Reference was made to being able to use
You're in jail. You don't have free reign.
Nexus or whatever it's called.
Yes.
We call it the law library.
Library.
The easier way to describe it.
I mean,
I'm only allowed to access the law library at certain times during the day.
LexisNexis is
The
on your
rule of
tablet.
the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells.
That's not true. They've testified that your tablet was brought to your cell.
My defense.
You're lying
How can
right
I work
now
on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it?
He said that his tablet came to his cell, that he has access
I
to the
even
tablet in the cell. So did the jail administrator.
Order that could be made by the court.
He's just fucking
to allow
lying
me
now.
more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need.
If you had attorneys, they wouldn't have a time restriction.
If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple of days to prepare for a trial of this magnitude.
Wait, during all that time, why weren't you reading all the documents?
Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident.
Good.
There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this.
No, not hate
It died
mail.
down for a little bit, but it picked right back up the closer we got to the trial. hate mail that comes from people right here in the city of Waukesha. Which
Again, how does
gives
that
more
prejudice you?
credibility to the venue needing to be changed.
Nope. Those people aren't your jurors.
Yet and still, that was denied. It's impossible.
It's impossible
For impartial jury to be found in this county. And that's not to
No, you found one.
discredit
It's your
people
jury.
in the county that can be impartial. It would be unfair to say that no one can be impartial. That wouldn't be accurate.
Then you got a fair jury.
But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this.
Because of what? What made it happen, Darrell?
The
What
reporting
why
live
did that
stream
happen?
on Court TV has comment sections where a lot of insensitive and nasty things are said.
Oh, guys, I hope our comment section doesn't say anything insensitive and nasty about Darrell Brooks.
The sheer insensitivity of,
That would be
some
terrible.
of the things that are said on there.
Wait, like you're a fucking retard? You're one of the dumbest people I've ever seen?
I know a lot of people
belong
probably
as
don't care about
fertilizer?
what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too,
Oh,
family too, loved ones too.
do you? Shit, I hope no one runs them over. That would be
also
fucking
have
terrible, wouldn't it,
been
you
ridiculed
ass?
and
You piece of garbage.
and had their names drugged to the mud and have threats towards them.
And of course, they didn't do anything to deserve it, but you are fucking awful and decided to
ones
kill
that had to
someone
leave
else's
their
loved
home.
ones.
Because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug.
Yes, it is. That's what you're trying
Whatsoever.
to do. You're trying to sweep everything under the rug. The fact that you're a fucking murderer. It all goes away because someone was mean to
constantly
someone else.
Say and report this incident as attack.
What was
Terrorism,
it then?
terrorism.
What was it, Darrell?
It's unfair and it's insensitive.
It's What was it?
It's a definite tragedy. Definite.
It's definite tragedy.
And that will
okay.
never be swept under the rug.
It's a tragedy? What happened? What's the narrative?
There's always going to be healing that has to take place.
Jesus.
It's going to be difficult. And that should not be swept under the rug whatsoever.
What are you talking about?
But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about.
That's not helping. That's not helping you at all. How many
And for
victims do
people
you
to
have,
paint a
Darrell?
certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive.
Which
and
picture?
It's not true.
Which picture?
I'm sure the court read through the motion for change of venue.
I'm sure they
I'm
did.
assuming, though it was a
Denied.
lot of paperwork in those motions.
Not that much compared to what the court reads
I think
every
it
day.
was obvious that the venue should have been changed.
You are wrong.
It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity.
It was denied because your legal argument
Zero.
wasn't sufficient. You did not demonstrate prejudice sufficient to require a change of venue.
There's so much bias that's going on that
He's almost done. I think like 2 minutes, one or 2 minutes left. Then the judge will respond
and
to
even
him.
with all this, for the record, we still have no proof of jurisdiction.
Oh.
We still have no bond on file in the docket sheet.
You didn't post a bond.
We still have no plaintiff. We still have no claim.
Plaintiff doesn't exist in criminal trials. Claim is a criminal complaint filed against you by the district attorney representing the state of
We're
Wisconsin.
not sure of the relationship between you, Your Honor, and a father of one of the people that was injured.
She disclosed it as a purely
Not
professional
Clear on
relationship.
that relationship, no matter how well prepared the speech was, because it was
It's
a
a good
prepared
speech.
speech.
It's a prepared speech.
That was obvious.
That was obvious. Okay. Well, if you got a prepared speech.
I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case?
No, appeal the refusal of her to recuse herself and then move the fuck on. If you wanted to delay his trial, by the way, he could do that.
If you hold the full judicial power of the state, or is it the military power?
The state doesn't have a military power.
50 minutes to make your various arguments. You've now repeated yourself a number of times. So I'm going to turn to the state to see if they have any response.
What do you do as a prosecutor here?
Thank you, Judge. Judge, I'm going to summarize what I just heard by
saying, here's the summary, right?
Why you think you done? Why you think you done?
Okay, number one, Your Honor. Just look at him. Look at him.
He talks like a
There's the state argument right there.
quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm
one?
so sorry.
Oh, yes, there was an echo. Too fucking bad.
5190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. The court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a Seventh Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
consent to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial.
Yep.
He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today, the resources of the state, the knowledge of the law, his ignorance of the law, and his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would
not that shocking,
throw
actually.
such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial.
Wrong.
It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the
What about my 2 feet shackled to the floor?
homework. And
She's
he's
pissed, by the
simply
way.
sitting here reading their notes,
Having to
reading
make this
their
argument would be fucking
cross-examination
infuriating.
questions and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial. And
Yep,
on the
here you
other
go.
hand, we're rushing him to this case and he hasn't had adequate time to prepare.
Yep.
He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. ex rel. George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system,
This is back in
paralegal
77.
training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he
So that case was even more harsh than what he's getting. In that case, now this was in the late 70s, so computer resources being way more expensive and difficult to access. You're not talking about just sending someone, a tablet in jail. But this guy was, demanded access to electronic stuff, and they said, no, you can't have that. Let's see. On May 2nd, 1978, petitioner George requested that Judge Kinney provide him with a typewriter, the use of a law library, and the same facilities that a bar association lawyer would get. In support of his request, he argued he had a right to proceed pro se without a legal advisor, without anything. The court again, for at least the fourth time, advised the petitioner of his right to counsel and of the disadvantages of proceeding pro se and the possible sentence he could receive upon conviction. After making a finding, the defendant intelligently, knowingly, and voluntarily waived his right to appointment of counsel. Judge Kinney, in order to protect the interests of the defendant, appointed an assistant public defender to be available at all proceedings to assist if the petitioner again changed his mind. He was also advised that he could at any time request the office of the public defender give him advice or take over his defense. So this is a completely different case here. And maybe he wants to cite that and say, well, according to that one, they could assist. They could assist. But he filed a written motion with the court requesting he be provided with white legal paper, typewriter, use of a law library, use of a photocopying machine, legal pads, paper clips, rubber bands, and copy of Chapter 38 of the Illinois Revised Statute. But this has been around for a while. They do this. They soak up the time and resources of this court. But let's say what Bay versus Indiana says real quick. This was cited earlier by the prosecutor. Here we go. We want to take this opportunity to examine the rights asserted in this, as in the other cases we've cited, by persons describing themselves as sovereign citizens by virtue of their alleged Moorish origin. Most of them are African Americans who belong to the Moorish Science Temple of America and claim to be the descendants of the Moors of Northern Africa, though they are not. Moors are of mixed Berber and Arab descent rather than being African American in the usual sense of being descended from Black Africans. The original purpose of MSTA, founded in the 1920s by Noble Drew Ali, whose followers call themselves Moors in place of more conventional designations such as Black, African American, and colored, was to claim government recognition and respect as full citizens rather than the second-class descendant of slaves. Leah Nelson, Sovereigns in Black, intelligence report from the Southern Poverty Law Center. MSTA focuses on uplifting its followers and encourages them to vote in U.S. elections so they can escape political slavery. The MSTA home office located in D.C. has issued a statement clarifying that the organization is neither a sovereign citizen movement nor a tax protester movement, was not founded for its members to become anarchists or conspiracy theorists. A MSTA temple in Georgia denounces sovereign citizen propaganda as completely asinine and asks that Moors not adopt the ideals of these European groups who at their core hate Moors' very existence. But clearly sovereign citizen ideas appealed to many self-described Moors who combine those ideas with Ali's teachings in an effort to reclaim and rewrite Black history. For example, the Moors Order of the Round Table uses 18th century treaties with Morocco to distinguish free Moors from African who could be enslaved, and teaches that courts have no jurisdiction over Moors, citing Nelson, Sovereigns in Black, Supra. Other groups claim that their Moorish nationality gives them the status in the United States of an indigenous people, although the logic behind the claim is deeply obscure. See the same thing. Rekieta Bay teaches that Europeans are latecomers and Moors never granted them citizenship. What do we got? She teaches her followers that they are Moors from Mu, who traveled to North America before Africans did, when the world had only one continent. Many sovereign this is what they're dealing with here. Many sovereign citizen organizations teach that whenever a Moor's name is spelled in capital letters in a government document, the name identifies not the individual, but instead his corporate shell identity, or in other words, a straw man controlled by the government. Although the Moorish Science Temple does not buy the sovereign citizen line, many of its members do. Many of them argue without any basis in fact that as a result of 18th century treaties, the United States has no jurisdiction over its Moorish inhabitants, who are therefore under no obligation to pay taxes. That is Bay's position. So this is Bay versus Indiana. But he does not explain how it entitles him to an $11.5 billion refund from the state of Indiana and or its subdivisions. nor is there any basis for his contention that he is not required to pay any taxes because being a Moor makes him a sovereign citizen. He may be a Moor, but we emphasize in the hope of staving off future such frivolous litigation. Bro, it's not going to happen. He is not a sovereign citizen. He is a U.S. citizen and therefore, unlike foreign diplomats, has no immunity from U.S. law. Indeed, his suit is frivolous and was therefore properly dismissed. He was lucky to be spared sanctions for filing such a suit. So there's some history on the Moorish sovereign citizens. That is the determination or like the background of how fucking ridiculous this is. Their sovereignty comes from the idea that they are Moors that came to America before Africans and did not give the white Europeans citizenship when the Moors clearly, as indigenous persons in all of those history books, were here first and colonized the area. Don't ask anything about actual Native Americans. I guess the Moors, I don't know what they did with them at all. This is where they are. This is what they're doing. What the hell is this? So I thought that was useful reading to understand the lunacy of where Darrell Brooks is coming from.
Basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on. Is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials.
He's downloading them from a retard wrangling website.
He has an agenda here. It's to stall, delay, disrupt, intimidate.
Don't say intimidate. The intimidation thing wasn't necessary. He's not intimidating.
Your Honor,
shouldn't have said that.
That's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to
I would just
hold
say
you up
fuck
from
off.
what you're
I'd be a bad judge.
gonna say, but that's a load of crap.
Mr. Brooks,
For her to sit there,
Mr. Brooks,
for her to sit
your
there,
Brooks, shut up.
objection is noted.
for her to sit there, Your Honor.
It's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various
The jury has been
points
just
that
sitting
you
there,
want to
by
bring
the
up.
way.
I then gave the
Not
state an
there,
opportunity
sitting
to
out in
respond.
the other
That
room.
is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded.
Okay.
Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other.
Many
Looking
times
at, for
every
example,
day.
his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that.
See, again, he doesn't know to file the appeal with the appeals court and request a stay of proceedings while the appeal is done. He doesn't know to do that because he fired his fucking lawyers. The court can't tell him to do that. Prosecutor can't tell him to do that. Her saying that right now, she shouldn't have even said it. frankly, because it's his responsibility to know that. Now he might actually file it. Could you imagine if this dumb motherfucker actually filed for an interlocutory appeal and requested a stay of proceedings and was granted it, and this shit had to be delayed for 6 months while that court did that? Could you imagine? I can imagine it happening. That's the sad thing.
Are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense.
That's a critical element of this, because one of the things I've been kind of skeptical on was how they finished up voir dire, because Brooks was the way his challenges were executed was a little bit suspect, but it's become pretty apparent, and I didn't watch it. We couldn't watch it, but it's become pretty apparent that this court has given him all the deference anyone could possibly ask for. And when he chose not to engage in voir dire in an at all appropriate way, you know what? I'm here saying fuck it. And if I'm here saying fuck it, like, believe me, fuck it. Because if the state failed to do its job on this guy, I would say he walks. Like, that, it would suck. It'd be terrible. It'd be horrible. But if the state fucked this up, then he should walk. The state has not fucked this up. The prosecution has been basically licking his fucking scrotum the entire time. The judge has been sitting there dreamy-eyed, letting him say whatever the hell he wants through all of this stuff. They have not impaired him in any way. They haven't even held him to reasonable rules of court decorum. They haven't even held him to the rules of court at all. They've provided him legal assistance that he is not owed. And still, he's bitching about it. So you can't convince me that this court has done anything other than be exceedingly fair. But what she just said there was that the state even agreed that if he challenged a juror, they weren't even going to mess with it. They had 1,400 jurors that they could go through. If he had a challenge for him, they just let it go. They'd let him do his challenge. They wouldn't object to it. Like, that much deference was given to him, and he still fucked it up. Spilatro says, Nick, Monty called Tug. We need to hear about this. Yeah, Monty, we went through Monty's thing yesterday. Monty is dumber than Darrell Brooks. Like, if there's a retard hierarchy, Monty is actually above Darrell Brooks. TMF Squid, wait a minute. So the judge has been giving this living pile of shit more than is required by higher courts, and he still wants to be an asshole. Yes.
Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court.
Again, the state has been really, really good in this case.
As
They
the
didn't
case
have
law
to.
says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact.
Yeah, okay. That's true.
There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling
like
objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that.
Yes, you do.
In a criminal case, the parties have.
Darrell Brooks wins. He should win now just because of that. God damn it. You absolutely have a First Amendment right to yell fire in a crowded theater. Don't do it. You may be liable for yelling fire in a crowded theater under the circumstances in which you could specifically not have a right, but you have a First Amendment right to yell fire in a crowded theater. There's all sorts of circumstances where that is true. And I'm not aware of any state at all with a law that says you can't yell fire in a crowded theater. But if there's a list of factors that lead to a certain criminal action from that yelling, then you don't have free speech in that statement, specifically at the time you utter it, with those factors present. In the same way that if I say this, hang that motherfucker, I want you to kill that motherfucker right now. If I say that, I'm pointing at nothing. There's nobody here for anybody to kill. All right? But if you take me and you put me in a place where I've got a crowd of people and then a person that I'm pointing at, I suddenly, I don't have the right to say that in that moment, at that spot, because that becomes incitement. But there's a whole bunch of times where you can yell fire in a crowded theater. Maybe it's part of the production that you're in. That's the easiest one. Well, the other easy one is maybe there is a fucking fire in a crowded theater. Second one is maybe you're an idiot and no one is expected to believe you that there's a fire. Like maybe it's obvious that you're not serious about it. Maybe you're Phil Collins singing that song. Fire, right? Like just yelling it out. Stop it. Stop it with this bad law. It was bad law then. It's bad. It's not even law. It's dicta. It's dicta. God damn it. Okay, hold on. I'm going to stop this one. And we're going to move to... I heard the judge made a ruling on the sovereign citizen shit today. So I'm kind of curious about that.
Impact either what he did beforehand or his testimony here. You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway.
We're going to allow what?
How?
It's what?
Wait, hold on. I heard he was absolutely ridiculous today. I thought it was at 6:30. Checking my timestamp someone gave me. Oh, no. It was 5:30, 6:16:49. Okay, so 6:16:49 is where this starts. All right, let's see what we got here.
Next question.
Grounds for the sustain, Your Honor.
Next question, please.
Any reason why the state of Wisconsin would be identified as the plaintiff when they did not file the complaint?
Objection, argumentative, misstatement of the law.
Grounds.
Sustained.
The grounds is argumentative and a misstatement of the law.
Grounds for the sustain, Your Honor.
Ask your next question, please.
Was that the grounds?
Next question, please.
The jury deserves to know this.
The jury will disregard that last statement.
They need to know.
I've sustained the objection, sir.
Okay,
Ask your
and
next question.
I've got a
please.
copy of her
I'm
written
aware that
order
it was
too.
Sustained. I'm aware. I just wanted to know the grounds. You can't keep hiding stuff from the jury.
Mr. Brooks, the court is not hiding anything from anyone, and the jury will disregard that last statement. It is not evidence in any way in this case.
The problem with these motherfuckers is you can't hold them in contempt when they do this shit. Because he's already being held.
Would it be fair to say that any case has a plaintiff?
Objection.
Grounds.
Lack of foundation beyond the scope of the witness's knowledge.
Sustained.
Would it be? Can I rephrase the question?
Just ask your next question. Just
Go ahead.
rephrase it.
Can't say whether it will be answered or not, but you can go ahead
But
and
I can't.
rephrase
I
it.
can't rephrase. Just so we're clear, whether it's answered or not, I can still rephrase the question.
You
I
have
don't
to
know
ask
what
the
the
question.
question will be, sir, so I can't make a ruling that's advisory. So ask your next question, please.
Are you aware that in any case brought into a courtroom, there has to be a plaintiff?
It's a misstatement of the law.
Grounds.
Same question.
Grounds is
It
not
also
the same
misstates
question.
the law, so sustained.
There's no plaintiff. How's their case?
Move to strike.
The jury will disregard the last comment and statement made by Mr. Brooks.
Grounds. There's a
It's a
defendant. There has to be a
misstatement
It's
plaintiff.
a
the law.
misstatement of the law.
It's not relevant. This jury will be the judge of the facts. The court is the judge of the law. Please continue, sir, or under 906.11, I will stop the cross-examination.
If there's a defendant, there has to be a plaintiff.
Mr. Brooks, please stop. The jury will also disregard that statement. It's a mischaracterization of the law. It's a misstatement of the law.
Based on what law or fact, Your Honor?
And I'll address that with Mr. Brooks once again after the jury has been excused. One final time, you may ask another question. Otherwise, I will, and it must not be along the same lines or under
Oh, God.
906.11, I will ask the state whether there's any redirect.
Say it again. Say what again? I dare you. I double dare you, motherfucker. Say what one more
You
goddamn
know of
time.
anyone who filed a claim in this matter?
You're done.
Objection,
Grounds,
irrelevant.
grounds.
It's also vague, so I'll sustain it.
So the grounds is vagueness.
And relevance.
Is it vague or is it relevant?
Both.
Sustained, Mr. Brooks. Next question.
This dude is trying. This dude, and I don't mean he is trying. I mean, watching him is trying my fucking patience.
So since your initial night of investigation, you've done no investigation since then in this matter.
Grounds.
Correct.
I think my monitor's.
And have you seen any news reports?
All right.
Objection, relevance.
Can I finish the question?
No.
You can.
This is
there's
a
no
really bad
identification,
question.
So under 906.11, meaning of, I'm going to.
If he asks, like, she's saving him here. If he asks the news report question, all the news reports come in. Like, the catastrophic nature of what he just asked, and here the judge is about to save his fucking ass. Because all this guy has to do is say, yep, I've seen every news report. Let me tell you what they say. Darrell Brooks drove SUV into crowd, killing 6, injuring 60 people. Darrell Brooks is definitely the driver of the SUV. I've seen your picture in the SUV on the front page of every newspaper in the country. You are a monster and a murderer. It says so in every newspaper. The jury's not allowed to know any of this, but you just asked the question. More appropriately, he just asked him. It's if it didn't matter, like if it didn't matter, or if it did matter, it would be it'd be the worst question you could possibly ask. It doesn't matter at this point because his case has gone so badly for him anyway, and there is no way around this. But my God, like it's one of the last questions you would ever want to ask a witness.
Sustain the objection without hearing the rest of the question. I don't see how it would have any relevance. I'll let you make an offer of proof after we're outside the presence of the jury, and if necessary, you can recall this witness. Next question.
In that case, then, since that is stated on the record, no further questions. I would like to finish at some point.
Sir, finish your cross-exam as to
Just
that
said
limited.
no further questions.
Okay, but as to that limited topic only. So if there are other things outside that topic, please finish your questioning.
I just said 2 times. I'm going to say it again. No further questions.
All right, thank you.
Okay,
then, sir.
good. Boom, done.
State have any redirect?
No
Nothing
redirect.
else. Thank you, Judge.
All right, thank you. You may be excused. I'm going to excuse the jury momentarily to take up a legal issue with the parties, and hopefully we'll have you brought back out shortly. You can use this opportunity for a comfort break, though.
I think he's about to get rocked.
You may make an offer of proof, sir, as it relates to why or what questions and what information you believe this officer would provide about news reports that he has seen.
So the offer of proof would just be to that one question.
Yes.
What would the question be?
The question was, would have been, if I was allowed to finish it, had he seen any news reports directly connected to the incident?
But what's the
The same
relevance for him?
thing that many other witnesses have been asked, and it was never sustained then. It was never even objected to. So it was the same. It was
Let's
essentially
focus
one of
on
the same
the
questions.
specific objection that was posed and my
And what was the grounds for
willingness
it?
to give you an opportunity to provide the court with an offer of proof. This was what relevance would this particular witness seeing news reports have to his testimony?
The same thing that
What
any other
relevance is
witness
it?
that was asked
Explain
the
it.
same question.
Which would be what? You have to be specific, sir.
I
I'm not
was
gonna
specific.
assume I
Saw,
understand what you are saying.
You have to
have they saw any reports related to the incident?
Have
That's
they
the same
seen-
question
have
that's been
seen-
asked by numerous
Well, there would
witnesses.
be a follow-up to that. So how is it relevant to this witness's testimony?
It's relevant to anyone who gets on the stand's testimony.
What's the legal basis you believe it's relevant to his testimony, sir?
It obviously forms an opinion.
Again, you need to explain to me, sir, the legal basis why you believe I should allow that witness to be asked that question and then any follow-up based on his
You
response.
never get this as a
What would
lawyer,
have
by
been
the
the
way.
follow-up?
What would have been the
I'm
follow-up?
asking
would've
you,
got
sir,
asked and it
you're
would've got
the one
answered.
who's the proponent of this particular.
If you are asking the question and he's like, what would have been the follow-up? He doesn't know what the follow-up question would be. So he doesn't know whether or not this question is relevant. He's insisting it is, but he can't articulate why. He can't articulate the follow-up question. Did seeing that news report influence your testimony in any way today? Did seeing that news report have an impact in your investigation? I don't even know who he's fucking talking to. Like, I didn't watch this today because I couldn't. But there are obvious follow-up questions to this question. Again, it's a terrible question to ask, but he could ask it and then he could just say, like he could give the reason that he's asking. What he wants to do is leave some negative inference without asking a follow-up question. But that means it's irrelevant. If you don't know how his viewing of a news story is relevant to his testimony, whether or not it makes his testimony more or less likely to be true, then you can't ask that question. The judge is giving him so much here to let him do this. You don't get to do this normally.
Testimony and this questioning.
The cop who
and
searched
the
his vehicle?
Evidence.
Okay,
So
yeah.
explain to me your legal basis for why you believe it's.
So, of course, if it's the cop who searched the car and found Darrell Brooks's ID, whether or not he saw a news report after the fact is completely irrelevant to the fact that he did these things. So there you go. But I mean, you could in theory ask the follow-up question. Again, you never want to open the door to news reports as a criminal defendant, because once you do that, they can just say, yeah, here's what I saw. You fucking ran over a bunch of people. I saw your picture on the front cover driving the SUV.
Relevant to ask, or any other reason, any legal basis you believe it's that I should allow that question to be asked.
I don't understand how you want me to answer that. I've stated the reason why I asked the question.
No, you stated it's obvious, but it's not obvious to me, so I'm asking you to explain it.
I also stated that I just clearly stated that it goes towards biasness.
I'm
That
sorry,
would
it
be
goes to
relevant.
what? Wait, it goes to what?
Oh, she's getting
Biased.
snippy.
Bias?
Biased.
No, bias, B-I-A-S. There's no T at the end. Bias. I want to make sure I understand your
now it's a
reasoning
problem with
correctly,
how to
sir.
correct
So
something.
it's,
How to
you're
pronounce
saying it
something.
goes to bias. How does it go to bias of this witness, sir?
How would it not go to if you see something in the news?
It's not a proper legal argument, sir.
Okay, well, I don't know how you want me to answer
How
that.
would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so what do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof.
Okay,
I said I
know
would
it.
recall the
I'm well
witness
aware-
if I
I'm well aware
determine.
what an offer of proof is.
No, you're not.
I'm well aware.
So make your offer of proof.
I don't need to. It's clear. It's very clear. I don't see anything funny either.
It's not funny, sir. It's a circular argument. You're
I
telling me
wasn't
that
referring
it's
that to you.
clear.
I wasn't referring that to you. The person that it was referred to know who they are.
Well, let's stay on task, please. So
I'm trying
it go,
to. but
you're
it's
claiming
hard.
it goes to bias,
May I
but
say
in
this?
what
May I say
way?
this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution
Judge
can
walking
ask
him through this
essentially
right here.
anything they want to ask.
Mr. Brooks,
But then when I object,
I had an objection before. Well, here's the thing. You want to go off target and you want
It's
to
not
bring
off
up
target.
things from the past. I can't explain to you why sometimes the state has an objection and other times they don't. But
That's
when
not what I asked.
when an objection has been made, it is my obligation to rule on it. And so there was an objection.
I'm aware of that, Your Honor. But I'm also aware of the fact, and it's clear that I object quite often, and every single time I object is just thrown to the side every single
Because your
time.
objections
I would
are bad.
disagree with that characterization, sir.
And why
I
would
make
you
my
disagree with
rulings
that?
in this
Why would
case
you disagree
based.
with that?
I'm like
Can
an
you point out
umpire.
one time?
I'm like an umpire in a baseball game, sir. I call and see the legal objections as I see them. That is my role, and that is what I do. And
Are you kidding me?
that's exactly
Your
what I
Honor.
do. I'm an umpire, sir.
Your Honor.
I am a referee in this
Your
trial.
Honor.
If you're the
And
umpire
let me
with custom-
finish.
Okay.
Let me finish,
Okay.
Mr. Brooks.
I
Your Honor.
apologize. I'm letting
So-
you finish.
Sometimes parties make objections, sometimes they don't. There can be a variety of reasons. You make a lot of objections in this case. From my perspective, okay, you make a number of objections. I rule on them and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence. So for example, if there's a relevance objection, I'm going to analyze that, okay, based on the objection that's been made. Sometimes I might think there's another basis for something to either come in or not come in. But my rule book, okay, is the rules of evidence, which are the
state of
statutes, which is,
Wisconsin.
once again, I'll point out, I gave you, sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you
There's no way, by the way, like she did give them to him. That's all she's obligated to do. Don't get me wrong. I'm just saying there is almost no way a layperson who has not spent tons of time studying the Wisconsin rules of evidence is going to have any fucking clue what's going on. Pick up the book and start reading. You can do it. You could pull up the Wisconsin rules of evidence and just start reading them without explanation. And it's not simple. It's not a simple thing. You have to read all the comments. You have to understand a whole bunch of case law. It's an entire semester of law school, and you don't even get through all of it. And that's just the federal rules. The Wisconsin rules are going to be very close to it, but a mirrored subset.
choose not to read them, that's fine. But you cannot then claim that there is somehow foul play because you haven't read them and you don't understand what they are. Your ignorance of the law is not a defense for any of this. Okay? And you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. And I will.
That hair
I've
curl is
asked you
trying to get in her
repeatedly
mouth.
for an offer of proof. You want to ask
just trying to get there
this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias, for which I will allow him to answer that. You haven't given me a legal or factual reason to overrule the objection and to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, but I recognize it's 3:25. It will be a good opportunity for a comfort break. And when we come back on, the state should be prepared to call the next witness.
Can I release at least rebuttal to what you just said?
No.
I don't need a rebuttal, sir. You may not agree with me, but I've made
It's not
my
about agreeing.
record.
You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record a rebuttal.
What would you like to put on the
record.
record as it relates to the specific issue for which I was giving you the opportunity to be heard? Not anything else, not subject matter jurisdiction, not
Now you
whether
said
the
that.
state's
I
doing
didn't
other
even bring
things.
that
I'm
up, Your Honor.
only asking you to address the offer of proof.
No,
If
I
you
want
have
to.
something, go ahead.
I want to
Only
address
as it
something else.
relates
I want to
that.
address your position because you said you're like the umpire, right?
Well, I'm not getting, okay, go ahead, sir. I'm not sure why you need to respond to
Because-
that.
Because it needs to be on the record. If you're the umpire, that means you're the referee.
It's another word
That's
for
what
umpire.
we're
I
doing
guess.
here
when,
today, sir.
and when you're not reffing fair if the jury's not allowed to hear things that's important for them to know.
I respectfully disagree, sir. Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction
I
doesn't
didn't
make
question
it
anybody
so.
about that.
Okay,
That was
it doesn't make
between
it
you
so.
and I. That didn't have nothing to do with a witness.
You've asked every witness.
I've-
who
I've
the
You
never
plaintiff
want to
is.
once
question
questioned a
these
witness
witnesses,
about subject
sir,
matter
about
jurisdiction.
whether they are aware of complaints. And the funny thing is, sir, I sometimes let that question be answered for reasons that are completely different, I believe, than why you want them in. I am not going to explain that
You
because I don't
can't. You
have
can't
to
say
explain
why.
that.
What's my reason for asking it?
Well, I believe you've made it very clear, sir. So here's the bottom
I
line.
don't.
One of my roles is to be the umpire.
Then you got to
All
be
right.
fair, Your Honor. You're a public
I
servant.
am fair, and I'm
No,
going to
you're not.
follow the
You're not
rules
being
of
fair.
evidence,
Your
sir.
Honor,
That
this is
doesn't
why I
mean
say
I'm
that.
being fair because I'm
unfettered
losing.
questioning
This is
of
why I say that.
witnesses that are not relevant or that call for hearsay.
How can you be fair if I
or
lose?
For a variety of other reasons that are speculative. There's a whole host of reasons in the rules of evidence, sir, that require me to make those determinations.
You're not being
I
fair.
respect
You're not
that
being
you
fair,
might
though.
not think it's always fair, but
It's
I
not.
disagree with the characterization. I think it has more to do with your lack of understanding of the rules of evidence and
Yes.
the rules of procedure, which you knowingly
This
and
judge has
freely
been
and
very, very
voluntarily and
kind
deliberately made a choice
on
to represent
rulings.
yourself. And
And you
as
keep
I
saying
warned
that
you at
because
that
it sounds
time,
good
sir,
on the
you did
record,
that
but
at
it's
your
not.
peril.
It's not accurate. You accept it when you gave me the paperwork, Your Honor. I
I'm
gave it
not-
back to
I'm
you.
not going in. I didn't
I-
say that, sir, so we can go back and rehash all of those things.
But you know you accepted
All right.
the way that I gave you the paperwork back. So once
And
you
I made
accept
findings
that,
on the record, which I will stand
Well,
by.
you accepted
sir.
what
So
and I'm not,
if that
I'm
were
not
gonna take-
arguing. I'm
we're
not
gonna take a
arguing your
break.
findings.
I
I'm
need
not
a comfort
arguing
break.
the findings,
I'm sure
Your Honor.
you need a comfort.
Whoa.
I would like to get through one more
You got
witness
it.
today.
You got
Thank
it. You got to
We're
call
off
it
the
fair.
record, sir.
You got.
Oh, they're muting. Oh, they muted they muted the court and cut him off. Arno 09, see if you can interview the judge after this is over and ask what she was using to keep her sanity during the trial, possibly compare beverages of choice. Beverages, that woman's got to have high grade pharmaceutical help to get through this. Let's see her ruling 649:43. So we got a couple minutes here. And then I go back. All right, here we go.
Before I have the jury brought.
Wait, here we go.
Before I have the jury brought out and the state calls its next witness, I want to bring to the party's attention that the court just now issued a decision and order in this case. I've signed it. Madam Clerk is pulling it through, and I will provide the parties with a written copy here in court. It addresses the matter of subject matter jurisdiction.
So we're going to address it.
No, I've issued an order. I'm going to give it to you. That's why I'm addressing it. You can review it.
She
later.
issued a written order.
There's a written
Is
decision.
it verified?
Denying
Is it a
your
certified
motion to
copy of the
dismiss.
order? Is it a certified
So
copy?
is that
Is it a
including
judicial
verified
determination?
proof that you have subject matter?
Does that include verified proof? You can just hear the fucking wheels turning. I took your motion for subject matter jurisdiction under consideration and I denied it. Does that include verified proof? Here we go, real quick. We do have the order here. It's just a 2-page order. Whereas a criminal complaint was filed on November 23rd, later amended on November 29th and January 12th, 2022. Whereas a contested preliminary hearing was held on January 14th, 2022, at the conclusion of which the court commissioner made a finding of probable cause that a felony was committed by the defendant and bound the defendant over for trial. Whereas the information was filed on February 10th, Whereas an arraignment was held on February 20th, at which time pleas of not guilty were entered, whereas the trial commenced on October 3rd, whereas the defendant has repeatedly orally objected to the court's jurisdiction over the matter and requested dismissal of the case, specifically claiming subject matter jurisdiction has not been established or verified, whereas the court has addressed the request on the record at various times since the start of the trial on October 3rd, but now believes it is important to issue a written decision on the matter. Subject matter jurisdiction in a criminal case is derived from Article 7, Section 8 of the Wisconsin Constitution, which states Circuit Court Jurisdiction, Section 8. Except as otherwise provided by law, the Circuit Court shall have original jurisdiction in all matters civil and criminal within this state, and such appellate jurisdiction in the circuit as the legislature may prescribe by law. The Circuit Court may issue all writs necessary in aid of its jurisdiction. Subject matter jurisdiction is the power of the court to inquire into the charged crime, apply the applicable law, and declare punishment. State versus Webster, citing State versus I can't read that. Aniston, maybe? Subject matter jurisdiction attaches upon the filing of the criminal complaint and continues until a final disposition of the case. The circuit court lacks criminal subject matter jurisdiction only when the complaint does not charge an offense known to law. It is clear this court has jurisdiction to preside over the trial to its conclusion. Charges were brought against the defendant by the filing of a criminal complaint on November 23rd, 2021. 2 amended complaints were subsequently filed. A contested preliminary hearing was held, following which probable cause was found, the defendant bound over for trial. Moreover, all the charges at issue are known to the law. So for these reasons, the court finds that the defendant's arguments are without merit. Denied the request to dismiss for lack of subject matter jurisdiction. It's not going to matter. He's going to keep going.
Jurisdiction. Because it has yet to be verified or proven.
Verified proof.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
So it doesn't have to be proven?
You are going to get a written decision. That's how I'm addressing this. And then I'm going to have the jury brought out and just providing courtesy copies to the parties as I had an opportunity to finalize that over the break.
I accept for value and return for value this document.
Thank you for noting that. All right.
It doesn't matter.
State has its next witness, I presume, ready to go? All right. When the jury's brought out, you may call the witness.
Oh, I thought she was going to yell at him more about this.
Is that verified proof that you have subject matter jurisdiction?
The decision and order speaks for itself, sir.
Is it verified proof that you have it?
Sir, I believe it answers your questions.
I don't believe so.
Unequivocally.
There's no verified proof proven yet.
Yeah, it's the same.
There's no verified proof if we're in common law or admiralty law.
You're not in
What court is
admiralty.
this?
The state of Wisconsin doesn't have admiralty jurisdiction. You're not in a court of admiralty. You're actually not even in a common law court technically. You're in a criminal law established by the a criminal court established by the Wisconsin Constitution under its judicial authority. Well, I don't understand. What court is this? It's the one where you're going to get proper fucked.
Sir, I believe your answers will be in that decision and order.
I don't believe so.
Well, have you read it yet?
I don't have to.
Okay.
I accept it for value and return for value. So
All right, they're in there, sir.
So what?
It's a final order. For
verified
purposes
proof
of
is in
appeal.
there? Verified proof
So
is in
if
there?
you'd like to challenge that, you can take that up with the appellate courts.
Verified proof is in there?
All rise.
Because I don't think it is.
You haven't read it.
Proof of claim is not in there either. No one has a claim.
It's actually really sad. Like for this guy, it's not sad because he's a piece of shit who mowed down a bunch of people. But there are so many people out there, which is more than one, that actually believe this shit. And they're constantly reinforced by bad actors trying to convince them that this is true. But it's never been true. I run into people like this. Friends of mine that I know are like, wow, but did you hear about this? Like, that's not a thing.
Thank you, everyone. Please be seated.
What do you mean it's not a thing? I read it on this website, and this guy knows what he's talking about. This guy doesn't know what he's talking about.
All right, good afternoon.
This guy doesn't know what he's talking about. Oh, no! So it's not just true because you read it somewhere. Because someone makes some argument that you find compelling. Well, I mean, Yeah, I mean, that makes sense. There is no state of Wisconsin plaintiff. Therefore, you can't haul me into court. That's real. No, it's never real. Show the officer that shot him. Isn't that long testimony? I've got the timestamp. I don't know how much longer we need to go with this. 2 minutes, 2 hours, 35 minutes. Shot at him. I heard this guy was pretty good. Holy shit. This is long testimony, though. Just go to the cross exam, maybe. His cross exam's long too. I don't know. I don't want to go through this. We've got unbreaded to do. We're already almost 3 hours in. This'll take a long time. He's on the stand for a long fucking time. Yeah, he's on the stand for an hour and a half. And the cross exam's like an hour of it. So maybe we'll do it a different day. Please do it. What, an hour more of testimony? Holy shit. Let's start it. Let's see what happens.
The Wisconsin one.
May call its next witness when the jury is out here.
Wait a minute. No, this is not the cross exam. Let me go. Cross exam starts.
After being given loudness, driven, yes, the person has entered, went right through the barricade.
Where the fuck does cross exam start? How many questions does Brooks ask this guy on cross exam? Holy shit. Okay, so here's him.
West, where you were both there, that intersection. One. And I
Hard
could
to
hear
figure out
squad
exactly
coming
where
from
this
that
fucking
area,
thing is.
So I blocked traffic to allow the squads to get through, and then I just continued.
But the fact, I did my best to describe the actual
Being here and not objection. I don't think he said lapel. I think he was just. I think he
Oh, he said
referred
he
to the
objected.
microphone just being here and not using it.
Yes, it does.
Move Exhibit 58 into evidence and ask to publish.
Okay, they're still asking.
Police protocol. So
The tired to there for service at the boat launch after 2 minutes, maybe.
would you say
Okay, it's got to be close to here.
That is correct.
that
Where the
you
fuck
couldn't
does
see
it
around
start?
that building?
Oh my God.
Did you start at East Main Street?
I do not know if you were armed when you were taken into custody.
A depiction of how the vehicle and the driver
Okay,
looked.
it's right in here.
Objection.
Oh no, not good, Darrell. There you are. That's your SUV. It looks like it just hit a bunch of people. Holy shit.
Now I'd like to show for the.
I'm sorry, I didn't quite catch that earlier.
Give you a chance to see if you recognize. What is
Right at 3 hours.
Statements that are on the right.
That is correct.
And what we saw in that video, again, that's inaccurate. Does that match up with how you recall the incident?
That is correct.
That's all I have, Your Honor. Thank you.
Oh, finally.
Right. Any questions for this witness, sir?
I do.
Okay. Jesus, sorry about that. Just fucking
You
annoying.
stated initially that you had heard some radio calls about a possible altercation at Frame Park.
That is correct.
Do you recall what the initial report of that was?
my recollection of that was that there was a call for service, is either a domestic or some sort of physical altercation along the riverfront in Frame Park, and that there was a male with a armed with a knife, and that he was fleeing from the area.
This guy looks like he ate an entire bison
So
right
it was
before
reported
court.
it was a possible knife involved and there was a male running from the scene.
That is correct.
And
He's going to go out this knife thing. Well, there was a report of a knife. Did
were
you find the knife?
ever given
No,
any
doesn't matter.
further information about the male with the knife that was running from the scene?
No.
Any information that the male with a knife running from the scene was in a vehicle at any time?
No.
Do you know if any investigation was done looking into that supposed fight at the park?
Yes.
And what did you learn?
I did not learn anything of it. I just know that squads were responding there to investigate it. I was not updated on their findings or what they had investigated. I just know that they were dispatched there for that investigation.
Do you recall if there was ever a knife recovered or a suspect recovered in that supposed incident?
Do you mean like how much later do I know? Like what I know now?
At any time. Do you know if there was a suspect, I guess I would say, apprehended or anything that was found with a knife, to your knowledge?
To my knowledge, I do not know if the suspect from that incident, which was you, was located
When you
with
say
a knife.
you, what do you mean?
You,
Who
Darrell
you
Brooks. I know you were the suspect in that incident, and I know you were taken into custody approximately 30 to 40 minutes later. I do not know if you were armed when you were taken into custody.
I'll let the record reflect that I do not identify by that name, nor do I know any individual by that name. I'm here in third party.
The record's noted, although the jury will disregard the comments, they are not evidence in this case. Next question, please.
At the time.
We Hear Well says, hi, Nick, my first Rumble rant ever. Hey, thank you. And I'm a big fan. If you can, please, can we watch the Ginger Cop from today at around timestamp 2:33? He fired shots in the red SUV. Cheers, brother. We're going to just watch cross-exam for a little bit. I don't know if I'm going to watch this whole thing because his cross-exam is like another hour of time before he's done. And it's already kind of late.
You said, did you respond to that incident at
For every $50 comes in, I'll extend the time by 10 minutes.
How
I'm
can
joking.
you know who
That's a
was
joke.
involved with it if you didn't
It's a
respond
joke.
yourself?
Jesus. I just hate
Because
when
you
people do
stated
that.
at any time this investigation took a long time to complete. And from this investigation, we determined that you were the suspect in that investigation.
You determined that?
I did not. No.
Okay. So basically, you just going off what you were told.
We're doing a Twitch subathon. Every subscriber adds 2 minutes.
Make any determination, nor did you investigate it. Would that be fair to say?
That's correct.
Oh, okay. Wow. Checkmate. Cop.
You also gave, and when you were asked the question of, were there any other officers along the route, or I don't know if that was referring to side exits or anything of that nature, but I recall you stating that you gave an estimate, stating that you weren't sure where other officers were stationed, but you gave an approximate estimate. Would that be fair to say?
That is correct.
And would that have been officers stationed at different cross streets?
That is correct.
Do you know if those cross streets were barricaded?
I know that there were barricades across numerous intersections for the parade route. That's how we shut down traffic in the downtown area for parades.
So pretty much every side street is barricaded.
I can't give you specifics on what streets were barricaded, but yes, the vast majority of streets are barricaded to stop traffic for the parade route.
Oh, so you didn't have anywhere to go. There, he's got
Can you
it.
pull up Exhibit 1
You know what? I'm going to give him credit.
and publish?
Aside from the fact that he's guilty as fuck, like that's part of his defense. And he asked a competent question to establish a fact that it would have been hard for him to leave the street. So he just had to run over the children. I mean, he would have turned, but he couldn't turn because the streets were barricaded. I mean, it's a dumb defense, but at least he elicited a fact related to his dumb defense. So good job.
Yes.
Can you see? Well, I know you can. Can you see the red lines on this map that we're looking at?
Yes.
And what do those red lines constitute?
Barricades.
Barricades.
Boom. Got him.
So would it be fair to say that there's a red line at every cross street that we can see on this map? That would be
Every cross street that
Start-
intersects the purple line.
start along the parade route, starting at
There you go.
East
There you
Main
go.
Street.
Specific
There's
questions.
a red mark. Oh, I didn't mean to put that arrow. Can we clear that? I was trying to put like a little dot. Starting there, there's a red line there. There's 2 at Buckley.
Hold on, and just so the record is clear, he put a mark at near the intersection of East Main and White Rock Avenue. So from that location to where?
There's 2 at
There was
Buckley.
no way out but through,
Hold
Your
on, we're
Honor.
gonna testify now. You gotta ask a question. So the juror will disregard that.
Are there
Of course
2
it
at Buckley?
backfires on him. The
Yes.
entire premise of it is stupid, but it's
Is there one at Martin Street?
Yes.
Is there one at is there 2 at Barstow Street?
Yes.
1 at Gaspar,
Yes.
1 at North Grand, and 1 at West Broadway.
There's 2 at West Broadway.
Well, this one is on the closer to where it says North Grand, and one is on the other side of the star right there. This is what I'm referring to.
Okay. Yes, there are 2
Can you
right
clear
there.
that?
Please clear that, Madam Clerk.
So there's 2 there. There's 2 at Clinton Street. Can you see those 2?
Yes.
There's 1 at Maple Avenue. Can you see that one?
Yes.
And there's 1 at right here at West Avenue. Can you see that?
Correct. Yes.
So it would be fair to say that there's pretty much barriers at every single street from White Rock and East Main to West Main and Northwest Avenue.
Yes.
Barricades at all those streets.
Yes.
Do you know if there were officers stationed at those barricades?
officers. Where can I find some
Yes.
officers?
This map shows, it appears where everyone was for their assignments that day.
So would it be fair to say if someone wanted to exit the parade route, they would essentially be blocked in by the officers and barricades?
No.
Jason of
There are
TGA.
barricades at these streets.
Is this
You can
trial
see
supposed
that
to be a
that's fair to
joke
say.
towards the woke or
No.
sovereign citizen crowd?
So
Either
it's not fair
way,
to say
I
that
don't
there
get
are
it.
barricades at these streets.
It's fair to say that there's barricades at the
The
streets.
sovereign
So-
citizen crowd is a joke.
Essentially, if someone was leaving the parade route, can they just go right through the barricades?
Based on the previous videos that we just were shown,
Not based on the previous videos. If someone was leaving the parade route, can they just go down these streets that are barricaded?
Yeah, I
Can
guess.
they just drive right out of there?
yes, the videos
How
show
when,
that.
how when it's barricaded?
Drive through the barricade.
As the video were shown
We're not
earlier,
referring
the
to-
vehicle
we're not
went right through the
referring to-
Well,
barricade.
when you ask
Oh,
the question,
shit.
then you have to let him answer that. He's giving you the reason. You asked him how. He's explaining it.
There's plenty of ways to get off the parade route. You can stop
You could just
after
stop.
being given lawful orders by officers, and they could have directed you off the
Stop, motherfucker.
parade route in a
You can put
safe
off the
manner.
pedal.
You could have stopped the vehicle at any point, or you could have driven through plastic barricades like you did at Northwest Avenue, where
Oh,
I was
fuck.
located. So yes, you can drive through plastic barricades.
Whoops.
You
refer to as who?
Darrell Brooks, you, the person that's talking.
The you? And how did you come to the conclusion of that name?
You,
As
Darrell Brooks.
you
Person
stated that you couldn't see past this building here, which you said is the Wisconsin House. Would that be fair to say?
Well, that's a compound question, so you need to rephrase that, sir.
You state clear this right there.
Please? Is that a please?
That a please?
Can
Pretty
you
fucking
clear
please.
this, circle and arrow right here. That's
Thank you, Madam Clerk.
you stated that
Everybody's
from
getting
where
fucking
you were
pissed.
positioned that you couldn't see around that building. Did you say that?
Yes, I did.
So it would be fair to say you also couldn't see what was happening along the parade route on Main Street. Would that be fair to say?
Well, if you guys want this to continue, you better hit that Rumble Plus button or I'm just ending the stream. Ending it right away. Now we got to get those Rumble likes up. We're at 3860 Rumbles. Let's kick that fucker up the chain. It's really, really appreciated. It really does help the show tangibly here on Rumble because, again, there is a leaderboard that tracks that stuff. So if you're enjoying the show and the commentary, go ahead and click it. If you hate it, don't click it, of course. TMF Squid, sir, may I ask you a question? How is it that you're a third party representing the defendant, but you keep referring to the defendant in the first person? It's a good question to ask.
That is correct.
So it'd be also fair to say that everything that you knew up until that point came over the radio and you didn't have firsthand knowledge.
That is correct.
Look, guys. Look, it's getting a little tough.
You also stated that
kind of running
after
low
a
on
few
Rumbles
minutes of
today.
hearing these, I guess,
We're gonna-
radio reports,
We're going to need to hit that goal.
you
Get
said
the Rumbles
after a few minutes,
up there a little bit
you noticed
before we can
something
get to.
was going
If you don't want
on.
to click the Rumble, then I'm going to have to
Do
go
you
to. I'm
recall
going to work
from
at Dairy Queen. You don't want to hit that Rumble Plus.
The reports,
Okay.
how long this vehicle traveled along the parade route? An estimate of the time that it traveled down the parade route?
I do not know how long the vehicle was on the parade route for. If I had to estimate, I would estimate approximately 1 to 2.5 minutes. 2 minutes, maybe.
Would you say it's fair to say that that's relatively a short amount of time?
I would agree with that.
So what do you mean by after a few minutes, you noticed something was going on?
Because after a few minutes, what I meant by that was the initial call for service at the boat launch, or for that domestic fight in Frame Park. From that time frame, from when squads were responding to there to the time that I had shots fired, that is what I mean by a few minutes. So you have to take into account the time for squads responding to that call.
I don't know police protocol, so just asking.
Yeah, we got that.
Mr. Brooks, please ask your next question.
I'm getting to it.
Okay, right, but I have to advise the jury to disregard the comment because it's not testimony.
And you stated that, well, let's go to
Yeah, go ahead. You don't need, do you need that? We're gonna turn it off.
yeah, you can take that down. Sorry about that.
All right, thank you.
I believe it's exhibit 57.
57 exhibits.
We pull up exhibit 57. Can we bring it to about 16 or 17 seconds?
Clack, clack, clack,
Can
clack,
you
clack,
bring
clack,
it back
clack.
a little bit? One more second, if you could. Darrell, can you pause it there? Would it be fair to say that those are barricades that are laying in the street there?
Correct.
Any idea why they were not standing up?
Yes, I do.
Oh God.
What would be the reason?
It was very windy that day, so when they were standing up how they normally are, they kept on blowing across the street. So we tilted them on their sides so they wouldn't get blown across the road, and they would still stay up there and block traffic.
They would be able to block traffic by laying down,
Yes, they serve the same purpose.
but they would be able to block traffic by laying down.
I guess I don't understand what your question is here.
Would it be much more easier to see them if they were facing upright than laying down?
What? What does this
I
matter?
think the height difference between them laying down and being upright is probably quite minuscule, because as you see, the legs that are now up in the air are approximately the same height as what the bar would be if they were standing up how they normally are.
And you come to that conclusion how?
Based on my training experience after deploying barricades on numerous events and working several parades in my work history.
So you would estimate that a barricade facing upright and a barricade laying down would be the same height.
Approximately.
Can you bring it back to 10 seconds?
Okay.
From what
This
we're
to
looking
me-
at right now,
These guys just sitting there, just
it's a little hard to see.
well, the plastic barricade that you could just
You can
drive
see
right
the
through,
vehicle,
it's all
you can
knocked
see
over.
where you identified you were, but it's a little bit hard to see everything. Would that be fair to say? Because of the person with the black coat and the gray hoodie and Nike black pants is directly in the middle of the screen. That'd
That's
be fair to
correct.
say it's a little hard to see from this.
Where it is paused now, yes.
Yes, that's what I meant. Where it's paused now.
Yes.
It looks like this would be you right here. Would that be fair to say?
That is correct.
It looks like you're firing your weapon right there. Would that be fair to say?
I do not know if I have pulled the trigger yet or not. I don't believe I have.
You were ready to fire at that point.
That's correct.
Do you recall what you were aiming for?
Yes, I do.
Can you state for the record and for the jury?
You, Darrell Brooks.
Again, you make reference to the you and the name. How did you come to that? Seeing as how you just testified to that you couldn't see anything before what you call the Wisconsin house. Would that be fair to say that you testified to that?
That's correct.
That is
And
correct. Correct.
you also stated that you learned additional information later on. Would that be fair to say?
That's correct.
So how could you determine at this time right now where we're looking at that you knew the suspect's name and the driver? Because you keep referring to you and then you saying the name. How did you have that information at this point that's paused right here that we're looking at?
I didn't say at that time I knew your name.
You referred to the name.
Yeah.
Did you not?
He knows your name
That's
now.
correct.
So how were you able to obtain the information about a name?
I did not know your name at the time I shot at you.
Who's the you were referring to?
Darrell
You.
Brooks.
Again, you say a name that you haven't answered how you came to that information. Were you told this?
Yes.
By whom?
I do not know who told me. Ultimately, I just know that throughout the course of the investigation, your name, you were arrested within 30 or 40 minutes, and you were identified as Darrell Brooks, who was the suspect in this incident.
So you either had to hear that name from either a report that you heard or someone told you. How did you come to the conclusion?
This motherfucker. You were arrested. You are identified as Darrell Brooks. It's you. But that's not my name. Checkmate. My name is Bahugla. It doesn't matter what your name is, brother. Like, if you go by some other name, you are identified by the state of Wisconsin as Darrell Brooks. I think you have a driver's license that identifies you as Darrell Brooks. You don't get to play this weird. Well, I don't recognize it. Well, it's weird because you've recognized it your entire life. All of it. And, well, you heard my name. It's you. It's you.
Name.
Oh, wait. We here well says, thanks for bringing us Ginger Viking. It's my birthday. Have a drink on me, you low down, dirty, rotten, mongrel, shyster lawyer. Oh, thank you. Thank you. TMF Squid, could I get into legal trouble if I sent this shit stain a copy of the wise words of Matthew Harris? Kind of want to see if it would distract him from defending himself. I don't recommend sending Darrell Brooks anything, but I can't think of any legal issue with sending him a copy of Death Sentences by Matt Harris. I don't tend to recommend doing, interfering with anything in any way at all, ever.
I'm assuming someone at the police department told me your name.
And you don't recall who that was?
No.
Even though you can cite the name so clearly and identify it and keep stressing it and stressing it, and you don't recall how you learned the information of the name?
That is correct.
That's correct.
So is it fair to say that you're just using the name based off what you're told and not what you were aware of?
What are you asking me?
Is it fair to say that you're identifying this name based off of what you told and not what you knew?
Yeah.
I'm saying the name based on the fact that you are arrested for this incident. You were identified during this incident. And because of that investigation, that is how we know your name.
Oh,
Would it be
shit.
fair to say, and obviously you said you've been in law enforcement for 7.5 years, correct?
Correct.
I'm sure you've done a lot of investigations in that 7.5 years. Is that fair to say?
Correct.
So you do understand that during a police investigation, any suspect is innocent until proven guilty. Would that be fair to say?
Yep.
That's correct.
And so with that knowledge, why are you so adamant about the name of the suspect that you just testified to not being aware of at the time? That you testified to, in fact, being told?
Sorry, I'm confused by your question. You say it again.
I think it was clear, but I'll say it again.
Thank you.
Well, I'll say it this way.
You could do it, Darrell.
Testified to not being aware
You could do a third-party intervener on behalf of Darrell Brooks.
the suspect's name at the time.
Correct.
You also testified to being told of the name, correct?
Correct. I don't know how I came about your name. I would assume it was through the investigation at the police department.
And were you, in fact, part of that investigation?
No, I was not.
Oh, so you weren't even
It would
investigating
be
a
fair
fine.
to say that by you using a name, you would not be sure. How can you be sure?
I'll object.
Grounds.
Argumentative.
It's been
Argumentative.
asked. It's been answered.
I like that.
It's argumentative. The objection is sustained.
Argumentative.
Please ask
How about that
your
one?
next question.
When asked about what you were aiming at when you fired, you didn't give a definitive answer. You were aiming for the driver?
I felt like I gave a pretty definitive answer. My answer was you,
You
Darrell
were aiming
Brooks.
for the driver.
Yes,
You, Darrell Brooks. The driver, you.
it's pretty definitive. I identified the person I was
So
shooting at.
what part of the driver's body could you see
Your face.
when the vehicle passed you?
When the vehicle was approaching me, I could see the silhouette of his face and upper portion of his
Just
body.
say your. You know it's him.
Can you describe what you mean by silhouette?
The upper portion of a person's body, I would say, from maybe chest, shoulders, and head and face.
Would it be fair to
You
say
said
that is a bust?
silhouette, though. What is a silhouette?
The outer portions of what would be like your shoulder down, your arms to your chest. The silhouette would be the outer portion of it.
That would be the upper half, not the silhouette. What do you mean by silhouette?
Objection,
The
argumentative.
objection is sustained. It's Mr. Brooks is not asking a question. It was argumentative. The jury can certainly
Would it be
decide what that means, but
Would
he's
it-
answered the question.
Would it be fair to say that that would be equivalent to a profile?
No.
What do you mean by a profile?
A profile would be sort of like a side angle view.
Oh, I need this officer to shoot at
Would it be
me.
fair to say that
Come
a
on.
silhouette would be more of an outline that would be kind of similar to a profile?
No, you asked him what a silhouette was. He described it in the way that he understands
I
it.
don't know exactly what you're asking here, but I can tell you when the vehicle was driving towards me, I could see your face. And then as the vehicle drove to my right, yes, then I saw the side of your face. And
Shit.
so then, yes, as a vehicle passes you, you see different portions of the driver, I guess you could say.
Well, that didn't go well for you.
So you aim towards what you can see.
Correct.
So that would be the upper part, as you say, you said the shoulder. You made I think it was your left hand pointing to your right shoulder, shoulder and up. Silhouette, as you say.
That is what I could see when you were driving at me. You asked me what I could see of you, and that is what I could see of you in the vehicle when you were approaching me.
The question now, though, is that what you aim for?
I was aiming at you. Yes.
At what you can see.
I was aiming at you in the driver's seat. Yes.
Shoulder, as you pointed to, and up, correct? Would that be fair to say?
What is the point of this
Yes.
question? Yeah, I'm trying to shoot you in the fucking face.
Firing a weapon of your caliber, would any of those shots be kill shots?
Potentially, yes.
Yes.
Would it be fair to say that firing a kill shot at anyone would terrify him?
Would scare them? Is that what he said?
I'm sure being shot at is terrifying.
Oh, terrify
Yes,
them?
it is.
Okay.
So it'd be fair to say you were shooting to kill.
No.
Yeah. I would. I'd shoot to kill him twice.
So would it be fair to say that, judging based on what you see, that you testified to a silhouette from about here that you pointed to, from the shoulder, using your left hand, you pointed at your right shoulder from here up, and you just acknowledged that any one of those three shots could have been kill shots. Would it be fair to say that you were aiming to kill? Shooting to kill, rather, not aiming to kill, but shooting to kill.
No.
So, in your estimate, what do you think you would have hit if you just testified to saying that
He's
you aimed
answering
at the
correctly,
driver?
but
What
you
were
want him just,
estimating
yeah, I
to
wish you were
hit?
dead. piece
Well,
of
my
shit.
intention was to shoot you in the upper portion of the body. However, my intention was not to kill you. My intention was to stop the threat that you were posing to everyone in the downtown area at the Christmas parade.
Oof.
Keep referring to the you again.
Yeah,
That's
you,
not a
Darrell
question,
Brooks.
so. By your estimation, acknowledging that those
This is
were
another
kill
problem of
shots,
self-representation
if
in
you
criminal trial.
connected
You just say
with
you
any of those shots, is it possible
rather than
the
defendant.
driver
There's no
could have been killed?
disambiguation there.
Yes.
And would it be fair to say that that's deadly force?
Yes.
Firing a gun is always deadly force.
Do you think it would have been possible to aim at the tire of the vehicle?
No.
No.
Why
Why
not?
not?
Would shooting the tire of the vehicle not
No.
stop the vehicle?
No, shoot the driver
No,
and
it
stop
would
the
not
vehicle.
have.
So a blown tire would, to your estimation, a blown tire would not stop a vehicle from moving?
Not at all.
No, it will not.
So it'll just keep on. It won't even slow down?
That is correct.
Yeah,
I'm
it's
trained to
like-
stop the threat. You were the threat. The vehicle was not. The vehicle was the weapon in which you used.
Fuck.
So that is why I shot at you.
There's the
Damn.
you again.
There's the
Pretty
you
funny.
again. Well, it was you. No, especially at 35 miles an hour. Cars have plenty of engine
Could you
power to
have
drive
well,
a
you
fucking blown
testified that
tire
you're
35
trying to
miles
stop
an
the
hour.
threat. And so would it be fair to say that that training constitutes shooting kill shots?
Well, we are trained in deadly force, and when we are presented with a deadly force incident, yes, we have to sometimes make that difficult decision and use deadly force.
Have you ever used deadly force before that incident?
Objection.
Grounds.
Prior act
Sustained.
evidence not relevant to this trial at all.
You said you're trained to use deadly force. So would it be fair to say that anytime you shoot your weapon, it would be deadly force?
Yes.
When it is directed at a person, yes.
Were you injured in any way during the incident?
No, I was not.
And at the time, being where you were positioned at, you've already testified that you could not see what was going on during the parade route from your position. So why did you feel the need at the time, not knowing the full extent of what was happening, to use deadly force?
Because as I previously stated, based on the fact that the radio traffic for people screaming for ambulances, and as different officers were getting on the radio, and it was progressively moving further and further westbound towards me on the parade route, that, and then officers saying someone was hit, which I initially thought was a physical altercation, someone being hit, but it was a vehicle versus person hit. Based on that, the vehicle speed at which, yes, I could not see it down Main Street. I only had a couple seconds at most until the vehicle from where I saw it was to my location. So based on the amount of vehicle damage, I knew the vehicle had been striking pedestrians in the roadway. And because of that, that's a deadly force incident. So that is why I deployed deadly force.
Not a good,
So you
not,
said you
not
knew.
good to have that answer. You
knew
knew.
what the
You knew
vehicle had. You knew. You
Yes.
said it multiple times. You knew.
Yes.
Yes.
How could you know if you could not see around the position that you were positioned in? How do you know that?
He just
Because
explained
based on
that.
the speed of a vehicle on a closed roadway during a parade, and people running out of the way so they did not get run over right in front of me, between all of those things, I knew what had just happened, and that is why I had to take action.
And you knew based on the radio reports.
No, based on what he
I would
just
say
said.
everything that I had just previously described, all of that encompassing, yes. that led up to my decision making into, yes, now I knew what had happened. I did not know previous to that what was going on. I did not know there was a vehicle on the roadway until I saw it. And it all made sense when I put everything together.
When you saw it, by the time you saw it, as you said, it was a couple of seconds. So at that point, did you observe the vehicle strike anyone from the time that you saw it?
No, I did not. I was focused on the vehicle. So I just remember that there were a ton of little kids and adults on the sidewalks. I knew there were a lot of children right in the roadway right there. And I remember seeing people like running, but I wasn't really paying attention to the people. I was just focused on the vehicle. So it was really all I was focused on at that point.
You weren't paying attention to any other people.
That was not my primary focus.
But you do recall that no one was struck from the time you saw the vehicle.
Yes, after looking back, after videos later on throughout the investigation.
No. From which you saw, from which you observed with your own eyes.
Okay.
No, I can't recall ever seeing someone hit right in front of me. No.
These questions just go around and around and around
Does
and
the
around
exhibit
and around.
videos that you saw here today, does anyone get struck in those videos that you saw today?
So now people didn't get hit by the vehicle.
not
Was
that I
it
saw
some other
today.
vehicle?
And you still made the decision to shoot to kill?
Yes.
That's correct. Actually, correction. I shot to stop the threat. If ultimately you would have been killed from that, that is a possible outcome.
You should have said good.
But you did testify that they were kill shots, did you not?
He actually did not testify they were
It's
kill
also
shots.
been asked and answered in multiple ways.
Do you recall what your shots hit, if anything?
Yes. Later on, throughout the investigation, when I
No, at the time, not later on, at the time where you fired the shots.
Mr. Brooks, you asked a question. He was attempting to answer it. So you have to
I
let,
was trying to give him clarification on what I meant.
but you have to let him answer the question that you asked. And if you feel the need for follow-up, then you can do that or ask a very specific question. But I'm allowing him to
Turns out this
answer.
officer shot 6
he was
people and
interrupted.
killed them in
Go ahead.
Waukesha that day.
I believe it was
3 bullets.
3 days after the incident. That is when I gave my voluntary statement to Detective Kirby and Detective Casey. And upon completion of that statement, I asked them if they could share any information with me. And during that conversation, I was shown a picture of the vehicle and where my round struck the vehicle.
At least he got him
You
on target a
stated
little
you
bit.
asked them for any additional information that they can give you. So it would be fair to say at that time, you still didn't have a lot of information.
Yeah.
Would it be fair to say that?
This is irrelevant.
That is correct. I didn't know where my rounds had struck.
When he got
previous
this
to that.
information is not relevant to anything.
Did you ask them in the
I did not ask them. I'm not a
in the
murderer.
statement that you just testified to, saying you asked them if they could provide you with any more information? Did you at any time specifically ask about the shots that you fired when you requested if they could give you any more information?
I do not remember the specifics of what questions I asked in pertaining to what information they could share with me. I think it was sort of
Who
a
cares?
generalization of what can you share with me at this point.
So would it be fair to say at that point that there's a possibility that you did not know the name of the suspect, nor did you know if you had shot the suspect at that time?
It's irrelevant. Object, relevant.
At that time, I knew I had not shot the suspect because the night of the incident when he was taken into
This
custody,
jury's going to ask for an SUV to come run them
it
over
was
during his
relayed to
testimony.
me that he was uninjured and he had not been struck by any of my rounds that were fired.
You do recall just testifying.
Yeah, I'm going to end this really
to
soon.
requesting more information from the detectives when you have the conversation with them. Is that correct?
That is correct.
And you said that you don't recall asking them about if your bullet struck someone. Is that correct?
That is correct. So
Now you're doing meta
the day I
testimony.
met with Detective Kirby and Detective Casey, that was, I believe, 2 or 3 days after the incident. Mr. Brooks was taken into custody the night of. So when I was still at the police department, I knew that he had not been struck. So I think we're dealing with the questions I asked of the detectives. That was not the same night of the incident.
I'm sure you asked, you didn't say it, but
You didn't say it.
you said you don't recall the information that you requested. Would that be fair to say?
Yes.
No, I don't recall specifically what questions I asked I don't know specifically what questions I asked of them a year ago. I know it was a generalized, what information can you share with me at this point? Because I didn't know what was going on in the investigation or what leads they had, or essentially what had happened after my involvement, I guess.
Oh my God.
So you didn't, it would be fair to say there was a lot of information that you still was unsure about at that point. Would that be fair to say?
That's correct.
So what?
So if there was information that you're acknowledging that you had no knowledge of, which would be essentially the reason why you would ask if they can volunteer more information to you, then
What is it?
how would there be any way of knowing if you struck the suspect?
Objection.
Grounds.
It's
That's the thing.
retarded.
It's a compound, confusing question, please.
I gotta stop. I gotta stop. Fucking stop. What is the fucking point? Would it be fair to say that a year ago, a couple days after the incident, you didn't know a whole lot of information? Yeah. Okay. What does that matter? Like at what part, like you got arrested that night. The evidence led to you. They've been going through the evidence that it's you. I mean, first of all, it was just fucking you. Second of all, we've got pictures that it's you. People saw you. Everybody's identified you. You know it was you. But what is the point of, oh, he didn't know at the time what my name, what the name of the defendant that I'm representing as third-party intervener was. Like, come the fuck on, man. Like, I can't do any more of that. I just can't. I'm almost glad I didn't have to fucking sit through it earlier. I wish I would have been able to, but I'm also glad I wasn't, because Jesus Christ, what a fucking idiot. Okay, let's see what time it is. What time it is. Here we go. Oh, baby, I think that might be. Oh, is that right at the end? Oh, perfect. Okay. All right. Let's do it. Okay, what's up, guys? It is time for the Daily Unbreaded. It is time for the Daily Unbreaded. We have page 538 of Death Sentences by Matthew Harris. Predicted when I was 16. At least you acknowledge it's better for a lady to go gaga than a man pretending to be a queen. Never, never, never. Drop dead, cracker, for telling me to behave myself. I'm not a junior. I never called my own father dad. I have no father. I never called another man an honorific. I never called another man daddy or grandpa. I don't respect elders. Kill all elders. High school spirit was bait and a racial attack. So kill Tommy Two-Tone. Overpowerful. Fuck your kaboom, baby. Park yourself in the North Plainfield. Death. African famine. Now you're going back to that. None of that share the world. Why would you take his advice? Climate changed where Chantel orangutan channel was hibernating. Dilate your little brother. Tell African to stop breathing. That's what makes us stronger, that no one cares. False. The most irrelevant people on the planet made a club and called that philosophy. It's not Sapphire anymore. So beyond you, it's unspeakable. You must be a bad actor in that car. I don't want to waste time hearing it. Feminist download from Chantel. Amber charred rangutan. Amber charred rangutan. Swallow a risotto while you're huffing. Bareback gorilla. Flanagal again. Remembers how to bleed. Pimple pops in brain like bust of Nietzsche. Little African get AIDS. Don't ever copy my music again. Oh, we're going purple Nile virus. Die from making your little brother gay. Now AIDS is back. Blood cancer to the world. We're operating on white bodies. Stop believing anybody is going to give you anything good. Stop pretending anybody is going to give you anything good. Worse than oppression. Zombie awareness campaign. Bleed the flood map. Wateroo get crushed radiation. Why wouldn't you wear a wire? Farajan Apayat out said women drain his power. Waiting for me to text his wife. Put Curry to the test. K positive. Non-monogamous Gopal drinks opal AIDS. Technically colored dream coats your face in fear. Just don't ask why it's a pea coat. Got Peter North again. Cart Sylvie to the freezer. Use Harris brand ant killer. Surge out to fix his jowls. Deep fry his heart extra crisper. Rogaine 911 factor that in cracker. Unbase yourself easy. Jerk yourself while DV cucks the white out someone else. Tell your father toss it downstairs. You'll catch it in the basement. Jack ain't shit. Don't give Deutschland to him. Flannelloss. Blood cancer, rot like little boys in his existentialist lectures. Caesar take a hard drive into a concrete barrier. Tell Amster to go away like she damned what matters. Gavin, put your feet down. You have no soul anyway. Dump Gavin, him 6 feet down. He has no soul anyway. Ale Andrino, draw a squid, swim on your stomach lining. Munger, lose yourself in a chink fetish. Extra entropy, grow old while you golf to sleep. Take football away. No wine in this house. I'm bread. What? What was that? I don't know. I don't know what that was. I don't know how to interpret that shit at all, frankly. But I believe it. I believe it. Okay, let's hit the Rumble chatters or the locals chatters. Zochi says it took less than 3 minutes from him to ruin so many lives. Oh, yeah. Cole, if the state doesn't exist, how can they provide totally not Darrell Brooks a lawyer? Volp, have you seen that he attempted to subpoena the state of Wisconsin as a witness? Yes, and the judge. Cindy, 29, fucked, and I know fucked. Nick Rekieta, November 15th, 2022. Joshua, 1 of 3. Steve Gosney is correct. Sovereign citizens have a form of delusion and should be treated as such. Tabby L. Also, recently in Wisconsin, in the small town I've lived my whole life, Wega, Tony Haas has been arrested for a double murder from 30 years ago. My dad has been best friends with the brother of one of the victims. It's been a long road, and I pray justice is served on behalf of the families of Tim Mumbrew and Tanya Togstad. That sounds wild. Jensen Zeiger says his argument is literally they are dead, so they can't charge me. Checkmate. Boomstick, dude. Damn Shaster lawyer won't hang out with us till dawn. Shaster. Some troll says, hey, Drunkada, my mom is your biggest fan. Hey, cool. Tell her I said, what's up? Service Vivas is objection. What is Cardinal? USA Now. Lazy Shaster lawyer. People can chat in any live stream till that session ends by paying $1. Don't have to sub. That's true. That's true. But you should sub anyway, because I end the sessions all the time. Bad Dragonite says, you know Rumble is legit because Lo-Fi Girl is on it. Lo-Fi Girl is on Rumble. That's true. Ia Cowden says, regarding the whole Admiralty Court thing, from what Legal Vices said, apparently the gold tassels on the flag were meant to designate an Admiralty Court, which you definitely don't want in case like this. In case like this, as he would be tried under maritime law, not common law, modern day equivalent would be a civilian tried under the UCMJ. Yes, and there would be a death penalty as well. Bad Dragonite says, you missed one very important topic. I'm calling you up for it. Thoughts on the squats coming back to 40K. It took them way too long to bring the squats back. But, you know, I'm glad they did. They're very popular. Brulham says, Rekieta Law, here's the unexpected Hangman Inquisition, hanging maps everywhere in their path. Let's get this pulled up for the chat here. We've got it here. There we go. There's no one expects the Hangman Inquisition. Sheep City and says, Darrell's whole argument is I hit some people's kin, but the state isn't a person. You got to let me walk. Legardicus, tell me, as a lawyer, does sovereign citizen bullshit sound like what I, as a sports ball fan, would see in a batter arguing with the umpire over a called strike on the grounds that a flag should have been thrown for a face mask, thus the pitcher should be given a red card and put in the penalty box for 15 minutes? Yes, even though that's just the rules of cricket. Sheep City and Rekieta Law, can we dub him Darrell Brooks, Royal Grounds for the Dindu clan? Yes. And then here is, what the fuck is this? Oh, this is a picture of a fucking idiot named This is a totally true 100% unedited picture of Montegraph. You can see right here. Very much drugs all over the place. Very, very bad of Montegraph to be doing this with all the drugs that he has. It's definitely true. Unedited picture of Montegraph doing drugs. Like a felon. Or whatever. Okay. Hold on. Oh, shit. Okay, next. We've got Mr. Wright over on Odyssey. Says, Judge Milf here licking her finger was just pure internet porn. Oh, come on now. Retro Gamer 19, throughout the trial, I expected the judge to raise her voice and tell him to shut the fuck up. Lady got more self-control than I did because I would have labeled him incompetent and put him in timeout. Yeah, and you probably honestly should be, but I guess. Max sent a smiley face. Retro Gamer 19, this man is just asking for Judge Mama to use that gavel on his fat head. Seriously, this dude make want to come across the street and run him over with an 18-wheeler. Okay. Next, we're over on Rumble now. Music and Fiction, cannot believe your Monty stream last night is number 2 on the leaderboard. How the hell does that happen? Well, by people clicking the plus. Click those rumbles. That's how you go up the leaderboard. Red Pill Girl from Mars says, 2 people told me my nickname is Lady Buckets and I'm Lamau. Well, when it's true, it's true. Christ, hello, please accept the honor of probably the very first platform-wide super chat from DC. I had to write Rumble support to be able to add my debit card. Your streams literally leveled up Rumble. By DC, do you mean debit card? Oh, very cool. Blue-Eyed Roof Korean says, wondered if prosecution would go for the throat with Brooks and try to break him. What sent him into his tirade was the dancing granny's testimony. Then the coup de grace was a medical examiner afterward. Teki Shinichi, have you ever felt bad for a judge before this case? No, and I still don't feel, I don't know if I feel bad for this judge. I have a little bit of respect for this judge, though, because I'd be screaming at him. Roy Rat, shout out to Birch Gold CEO. I think Monty said it was Mr. Can't Say His Name. The guy has a great sense of humor about selling shekels. He also says, Mr. Rekieta, have you ever thought about reviewing some medieval court cases for fun, like divorce cases involving mutual combat? They are as hilariously weird than divorce civ crim cases today. Never thought about it, but maybe. Barb Loves Alaska says, let's see. Brooks knows that every day he's getting closer to hearing them words, "Get that butt," as he walks to his cell, his new future residence. Brooks is going to have a bad time in prison. Who are we kidding? Brooks will probably just live on in prison forever, and no one will ever mess with him. Wilcox, MD, not being informed to the highest degree of accuracy, I hesitate to articulate for fear I may deviate from the true course of rectitude. Tech Crisis, this must be the most patient judge in history because I would have snapped. Stardust Crusader, 89, I can't wait till Darrell Brooks is convicted. I hope he loses his shit and gets pummeled by the bailiff. But Your Honor, how can I be convicted if the state hadn't proved they have jurisdiction? There is no plaintiff. How I just don't understand, Your Honor, how I could be jurisdictionally convicted. Cowdenine, we should watch the judges in the state's response after he is done. The blow his argument apart in under 10 minutes, and it's hilarious. Lumber Lady, shout out to Hayden, Aussie Overlord, for staying up till 9 a.m. to stream this for us Americans while the other state lawyers failed us. It's true. It's true. And I think I have to fail you on Monday too. I'm sorry. New thing just came up. I was definitely going to stream on Monday, and now it's looking like I might not be able to. Kimberly 777. Now, Nick, you need to stop making fun of the way he pronounces words. I will not. I will not. Judy Brady says, and the jury is sitting in a sweaty room now. Frenchie JJ, will the state of Wisconsin please stand up? Please stand up. Please stand up. White guy. Your Honor, if I try to log into my criminal account using all caps in my password, then it will be rejected. Therefore, this name is invalid. Motion to dismiss on a 403 forbidden error. Motion granted. John Kirstian says, imagine if he had a lawyer and watch him argue with them. Frozen Smoke, why is the judge allowing him to speak for so long? Because the judge is being overly deferential, so he has no ability. There's no ambiguity that the court has given him more than a fair trial. They're giving him more than fair trial. Robot 72. If only this guy was driving an EV, the death and injury toll would have been halved. John Kirsten, they believe the actual natives were black, and what we think are the natives just appropriated black culture. Look up Hotep Jesus. He talked about it on Rogan. Wrestler Town, the fire in the theater example is understood to mean when there is no fire and the claim of fire causes panic injury. This is intuitive to everyone who hears this, except for lawyers for some reason, because you can't make a definitive statement that you have no right to yell fire in a crowded theater. It's not actually case law. It's dicta from Schenck, which is about a completely unrelated issue. And Oliver Wendell Holmes would go on for the next several cases trying to undo the damage he did in Schenck. If he wanted to make it as specific as you did, that would be fine. But he didn't. And everybody cites it as if it's true. But it's not controlling law in the USA. In fact, if you made a law that said you cannot yell fire in a crowded theater, it would likely not be valid under First Amendment principles. That's why lawyers take issue with the Schenck decision and with people citing to it. It's just not true. And again, I would challenge you to find the state that has a law that says you can't yell fire in a crowded theater. Redone 777. Nick, best witness of this trial was the bearded officer. Cross-examination was so funny as hell. Well, we just watched a chunk of it, but it was getting really, really long. Casparius says, for fudgesicle's sake, can I object on grounds of argumentative? Roy Rat, I think Judge Darrow should be invited into the grift. This case is more than enough to retire from the bench. And the audience is going all Scandi Berserker. Her channels would get instant subs. The most banned queen says, I think I just got Monty to agree to an interview. Well, you do that all you want. Montegraph is an insane moron. And if you want to entertain him, you do that. I will just laugh at him and he'll go away eventually because that's what he does. Mandy Karavich says every 50 cents, 2 hours to go. Redone 777. Darrell Brooks. I don't identify by that name. His mother takes a stand. Mother. What's up, Darrell? Jason of TGA. Why is Eric the Viking there? Jen Cavax. I'm at 350 pounds and need motivational fat shaming. Roast me. Dude. Gen or Jen Cavax. I can't roast you. I can't do it. Do you know how dangerous it is? If you're anywhere near a theater, roasting you would start to render the fat. The fat would eventually ignite and burst, causing a grease fire of unparalleled proportions. The great fires of Chicago, Rome, nothing would compare. The burning of Prospero would pale in comparison to your rendered lard igniting. Whole towns, counties, states would be at risk. Women would be screaming in the streets, but then choked out by the ashes left in the wake of the roasting that you would get. So I will not roast you because I care about humanity. And if you cared about humanity, you would find a treadmill and pray to Christ. It can hold you up. The Fish says, okay, he got his due process. Can someone pink mist him now and give him that speedy trial? Roy Rat says, at We Hear Well, happy birthday from a certifiable Viking. Oh, happy birthday. That's nice. JD 522, I'd like to smash the judge's rumble button. Damn. Mario Carter 13, the judge is frustratingly schizophrenic. She'll let him opine for hours on end about shit that doesn't matter 1 minute. Then the next minute, she'll make a stupid mistake that risks bringing him on appeal. She hasn't made any mistakes that risks bringing him on appeal. I want to be very clear on that. The judge has not done anything to give this guy an appellate issue that is at all valid. Roy Rat says, Nick, do you suppose Bahugala Brooks had Static X's Wisconsin Death Trip for his GTA 5 live soundtrack? Yes. Yes. No Guard says, I miss Borowski. He would have ordered the bailiff to kneecap the defendant by this point. I know, he's such a hero. Spatula Guy, I wish I was her lock of hair trying to be in her mouth. Seal Hunter sent the same, it's the same image from before of Montegraph doing all the drugs. Have I ever thought about having Matt Bracken on? I don't know who Matt Bracken is. Okay. I think Baldo Gagger did say, Nick, he should be told that the state of Wisconsin will appear in court when Darrell Brooks does. That's a good solution. All right, guys. I think that's what we got for tonight. I got to get up early tomorrow, so wanted to do 3 hours, but we did about 4. Not so bad. I will see you guys. If nothing else, I will see you Monday. I have returned to Twitch, so I should be able to do some Twitch streaming over the weekend. As always, rekietalaw.locals.com is the best place to follow, to make sure that you know where I'm streaming and what I'm streaming at all times. Also, to engage in the live chat on rekietalaw.locals.com. That's where all of the unbreaded chatters have ended up. And I think people are finding it to be quite a fun and raucous place. So you should check that out as well. We will, until next time, peace. Where the fuck is it? Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a Balmore, a Lafroig. The spirits blow as the ones who get unemployed. So pour out a glass for the deposed on Twitter, as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the deposed on Twitter, as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law